start, Dr. Murthy?
Yeah, I will introduce something. Thank you. Good morning. Welcome to the second day of AAPI CME sessions. I am Dr. Vemuri Murthy, Chair of the AAPI Summit 2020 Webinar CME Committee and the Program Director. Hope you all enjoyed yesterday's CME session. Our committee has incorporated two special courses, namely a 2-hour medical ethics course yesterday and a workplace harassment course for 1 hour today. As you might be aware, these courses are mandatory for physician license renewal in some US states. We are also providing medical legal information course today based on the US compliance laws for physician practices. We thank the leadership of the Chicago Medical Society for providing Category 1 AMA CME credits. Before I introduce today's session moderator, I welcome the AAPI President, Dr. Suresh Reddy, and the Chair of the Board of Trustees, Dr. Seema Arora. There are some important announcements. Dr. Arora, Dr. Suresh Reddy, you're on. Thank you.
Yeah, thank you, Dr. Murthy. I'll not take much time, and thank you all the audience for joining this early morning on a Saturday morning. I hope you had your coffee. We have wonderful lectures Dr. Murthy and Dr. Vasa has lined up. These are my mentors and role models in the Chicago area, and very proud of them, very dedicated, very meticulous, very planned. Thank you all. And I have an announcement today, and that is the Prime Minister of India, Mr. Narendra Modi, Honorable Prime Minister, will be addressing the AAPI members today at 8 p.m. Eastern Standard Time. That will be 5:30 a.m. in India. And he will be addressing from Delhi. And thank you so much. Please join us. The web link is on AAPI website. Unless something extraordinary happens at the Indo-China border, he will be joining us. Thank you so much.
Thank you, Dr. It's my pleasure now to introduce the moderator for today's session, Dr. Rohit Kumar Vasa. Dr. Vasa is an attending neonatologist, Ann and Roberts Lurie Children's Hospital of Chicago, Northwestern University, and neonatology site leader and chairman, Department of Pediatrics, Mercy Hospital and Medical Center, Chicago, Illinois. Dr. Vasa.
Thank you, Dr. Murthy and Dr. Reddy. Let's go ahead and get started with the program. We have multiple sessions this morning with diverse topics, and every speaker is an expert in the topic that they are assigned to. The first two sessions are an hour long, and the third 45 minutes, and fourth is 30 minutes. I would request the speakers if they can finish maybe 3 to 4 minutes prior to the allotted finish time. We can bank those saved minutes to the question and answer session at the end. We'll try to address as many questions as we can. Questions keep coming in chat. We may not be able to get to all the questions, but we'll try to get to as many as possible. So let's start with the first session. And the topic for this session is Fraud and Abuse Compliance Update, COVID-19 and Physician Liability. And it's a team of speakers, Clay Countryman and Catherine Marist. Both are JD, both are partners in the firm Brazil, Sash, and Wilson Law Firm in New Orleans and Baton Rouge, Louisiana. Clay Countryman is board certified in health law specialist. He's a health law specialist and certified by Louisiana Board of Legal Specialization. The platform is yours.
Thank you. Thank you, Doctor. Good morning. And good morning to everyone who's joined our presentation this morning. I know it's always exciting to get up on a Saturday morning and hear about fraud and abuse and compliance and how you're doing in your business practice. So we promise to make this as exciting and worthwhile as possible. There's a lot of information, good information, we're going to try and squeeze in an hour, and we welcome your questions at the end of our presentation this morning. Just a couple of comments. Again, my name is Clay Countryman. I'm a healthcare attorney based in Louisiana, and my partner, Catherine Mare, who's going to speak at 8:30. We do practice all over and primarily or in the healthcare area. I represent all kinds of healthcare providers, all types, but primarily physicians in private practice, as well as employed physicians from time to time. So, and I do want to, and I'll squeeze in, I'm a native of Chicago. You may not hear it in my voice, but it's been a few years since we moved south in 1973 and 74, but I do miss the Windy City. So I'm assuming that the audience does have our presentation slides in front of them. And I'm going to go through the slides and I'll comment on which slide I'm on. So the first slide that, of course, is the focus of our presentation. And our focus is going to be, we're going to talk about fraud and compliance risk for physician practices. And it's going to be focused first on walking through 3 primary federal statutes that apply to physicians. This is on the slide that says focus of presentation at the top. Can't remember if I advanced them or you all advanced them, but we're going to talk about the Federal False Claims Act. We're going to talk about the Federal Anti-Kickback Statute, and we're also going to talk about the Federal Self-Referral Prohibition, otherwise known as the Stark Law. We're going to discuss current compliance issues for physicians. And the slide says pre-COVID-19 and during COVID-19. And I put that on the slide to emphasize we're going to discuss compliance issues with your business practices that existed prior to the pandemic. And Catherine is going to get deeper into compliance issues and recommended practices and procedures to use to be in the best position to deal with those compliance issues during and after the pandemic. So the next slide I'm going to talk about is, just want to mention, this slide says the should say Federal Civil False Claims Act. Oh, good, there's my picture. We go one more slide, and this is the Federal Civil False Claims Act. And I want to mention this is the primary statute that is used by the federal government to prosecute healthcare fraud. So if you have a allegation of a kickback in a business practice or an allegation you might violate the Stark Law, it's more than likely to have risen in a whistleblower complaint that violation of the anti-kickback results in a violation of the False Claims Act, because any claims that were generated out of that particular practice were false, and so violate the False Claims Act. And my partner Catherine, who's a former federal prosecutor, is going to discuss that more in detail. If we skip ahead 2 slides, one more slide, we're going to talk about the Federal Anti-Kickback Statute for a minute to frame up our discussion on current compliance issues and best practices that we would recommend you use in your operations. The Federal Anti-Kickback Statute, it is a criminal statute, and a violation of the Anti-Kickback Statute makes it a criminal offense to knowingly and willfully offer, pay, solicit, receive any type of remuneration, either directly or indirectly, to induce or to reward referrals of any services or items payable by a federal healthcare program. And remember, a federal healthcare program can be Medicare, Medicaid, can be TRICARE, could be the Federal Health Employees Benefits Program, any type of federal program that pays for healthcare items or services. Now, to the Federal Anti-Kickback Statute, there are also certain safe harbors, which you may be familiar with, that are in the statute and also adopted by regulation by the Office of Inspector General that describe practices that if you meet all the conditions of the safe harbor, then you should not be prosecuted for that particular practice, or you will not be prosecuted. Even though you rarely meet all the conditions of a particular safe harbor For example, there are certain safe harbors for joint ventures. They're called the small investment safe harbor and the investments in larger entity safe harbor, but they have about 8 conditions in each, and those conditions require a certain percentage of investments to be held by non-referral source investors. So they're difficult, but we always recommend that as a goal. With the anti-kickback statute, there's certain penalties and fines, unfortunately. It does constitute a felony with a maximum fine up to $100,000 and imprisonment up to 10 years or both. A provider can be excluded from the federal healthcare programs for violating the anti-kickback statute. But there are also civil provisions in the anti-kickback statute, and I want to highlight the the third bullet point on this slide. Under the civil monetary penalties law, penalties for violating the anti-kickback statute may also include 3 times the amount of the kickback, the amount you receive or paid for a referral services, plus up to $100,000 per kickback, and also potential liability under the False Claims Act. Just a comment at this point, any violation of the, a lot of people say, well, let's only do patients that are not federal patients, and we don't have to worry about these federal statutes. Well, not necessarily so. There are several, if you only provide services to patients who are self-pay patients or commercially insured patients by Blue Cross, Aetna, United Healthcare, etc., you can still be have potential liability on one that's called the Travel Act and other federal statutes if you potentially violate a state law or there's interstate commerce tied to that. I just wanted to mention that. Next slide, please. People say, well, what's remuneration that's going to trigger the anti-kickback statute? The remuneration may include any cash, anything of value. And one of the things I want to emphasize, there's been a lot of settlements lately based on hospitals and other providers who have provided employees, let's say a nurse practitioner or a physician assistant or clerical administrative employees, to physician practices to assist them. And this is primarily before the pandemic. And that is value. That's a lot of value. And those have been the basis of settlements based liability, both for the hospital or health system and for the physician themselves. I'm going to skip through some of these slides because there's a couple particular slides I want to get to. This slide lists some common arrangements that the anti-kickback statute has been applied to. When I say apply, that means either the federal government or the Office of Inspector General has scrutinized a particular arrangement, like a co-management arrangement by a physician practice or clinic with a health system. I've listed medical director agreements, physician employment and professional service agreements where the amount of compensation has been scrutinized, and so forth. Next slide, please. The next statute I want to briefly mention is the Federal Physician Self-Referral Prohibition, the Stark Law. Next slide. In short, the Stark Law has 2 prohibitions. Under the Stark Law, a physician is prohibited from referring Medicare and Medicaid patients for certain designated health services to an entity, for example, a hospital, with which the physician or family member has a financial relationship, unless it meets an exception. The second prohibition is that entity is prohibited from billing or submitting claims for those services to Medicare or any payer for a service that was furnished as a result of a prohibited referral. Of course, unless the arrangement is in an exception. There are several exceptions. The employment exception to the Stark Law, there's the professional services exception, and exceptions for financial relationships such as recruitment arrangements. The next slide talks about the types of designated health services that trigger application of the Stark Law. I'll put in bold the last point, dealing with inpatient or outpatient hospital services. So any service that a physician, if you refer a Medicare patient to the hospital for lab services, for radiation therapy, for physical therapy services, and if those services are billed as a outpatient hospital service, it triggers application of the Stark Law, for example. Next slide. This slide lists the potential fines and penalties for violation of the Stark Law. I'm not going to go into detail, but you can see they're quite extensive. And then I want to go to the next slide. I've listed some common compliance programs with the Stark Law. I want to highlight some of these. First one, paying physicians more than fair market value. For example, when you become employed by a hospital, or you provide professional services, or a hospital purchases your practice, or you do a joint venture to invest in a surgery center with a hospital or health system, you should always have a valuation on the amount of compensation that is paid in those arrangements. It gives you a range of the fair market value. There's been several settlements and cases brought in the last few years, several years, based on physician compensation, even though I know that's a whole different subject. Let's see, other points on this slide: paying physicians even though services were not provided or needed, subsidizing physician practices, financial arrangements without a written contract, or performance of services after an agreement has expired. Next slide, please. The next few slides, I want to point out and remind everyone that in March, on March 23rd, the Centers for Medicare and Medicaid Services, as opposed to Chicago Medical Society, where it says CMS on this slide, I'm referring to the Medicare program, issued certain Stark Law waivers during the pandemic. And what those do is they waive certain parts of exceptions, compensation exceptions, requirements during the pandemic and financial relationships if the particular financial purpose and relationship is due to purposes of the COVID-19 outbreak. Next slide, please. I just want to mention these slides because on this slide and the next slide, this is how the Centers for Medicare and Medicaid Services defines what's a COVID-19 purpose for the Stark Law waiver. You know, for example, a diagnosis of providing treatment for COVID patients, securing the services of physicians and other healthcare professionals, ensuring the availability of healthcare providers for patient needs. And what I want to emphasize, these waivers, while there's still many parts of the Stark Law still apply, they are ways where hospitals and health systems can do rent abatement. They can forego rent during the pandemic. They can assist physicians in other ways to secure and make sure they have services, physician services available during the pandemic. So there are ways that, you know, we've worked with a lot of physician practices who have had some severe financial issues and have been able to find ways to find support from different hospitals and health systems that are traditionally referral sources between the parties, but we're able to structure an arrangement to support them during the pandemic. And those issues and questions are coming back quite rapidly again, as some of the states around the country are having a uptick in COVID cases and hospitalizations. Next slide, please. I'm going to go one more slide. And on this slide, I start to give examples, and these aren't necessarily my examples. These are examples by the Medicare program of what the Stark Law waivers during the pandemic can be used for. For example, you know, the last point talks about delays in rent or abatement of rent, furnishing space, equipment, or personnel to a practice to assist them when necessary for related to services for COVID patients. Let's go ahead, 2 slides. Trying to be a good steward of my time this morning. This slide, the it discusses how the Office of Inspector General also issued what they call a COVID-19 policy statement on enforcement of the anti-kickback statute during the pandemic. What the OIG issued on April 3rd in their policy statement specifically said they will use their discretion regarding enforcement of the anti-kickback statute on relationships where a financial relationship falls within one of the Stark Law waivers. So basically, if you have a loan or you have extra payments or support from a referral source that fits within the Stark Law waiver, the OIG has expressed that they will not prosecute someone or seek any kind of civil penalties or fines under the anti-kickback statute or other statutes under their authority. All right, here we get to the juice. You always get to the juice for the last 10 minutes or so of a presentation. On the next couple of slides, I have given examples of recent settlements that what I feel are trends in healthcare compliance and healthcare prosecutions and enforcement by federal and state agencies and medical boards. For example, the first on this slide I talk about in August of 2019 with Quest Diagnostics, they paid $88,000 to settle allegations of kickbacks in the form of collection, processing, and handling payments related to the collection of blood that was paid to physicians. And I mention this because in each one of these cases, even though this describes how Quest or hospitals paid certain amounts to settle cases or civil monetary penalties, in each one of these cases, I did see there was a corollary investigation of physicians who received payments or receive referrals of services. And I'll highlight that point. The next one talks about a hospital. Here we go. Union Hospital in Maryland, they paid $457,000 based on providing free support to physician practices by furnishing physician assistants and nurse practitioners to work in the practice. These were allegations under the anti-kickback statute, and they were settled by paying these penalties under the civil monetary penalties law. And then the next settlement on this one, this is very interesting, at least to me. The basis, it was a whistleblower complaint regarding a hospital that had purchased a physician, an oncology practice, and they also purchased their infusion bay and their infusion services, and that the whistleblower complained that the amount of compensation was based on the wrong set of work RVUs, to inflate the compensation to the physicians by 500% from what they're receiving before, because it was really compensation for the oncology patients and the infusion services. And the physicians had complained that they were not receiving adequate compensation for purchases of their practice, as well as employment and their infusion services. Next slide, please. On the next two slides, this is where I discuss in detail some trends in healthcare civil enforcement. The first one I mentioned, laboratory services and related compensation arrangements. Almost, I would say, if not daily, weekly, we see cases and settlements being posted by the Office of Inspector General where they have settled with a laboratory company or executives of the company or physicians separately based on receiving alleged kickbacks or remuneration for the referrals to genetic labs, to other types, to urine testing labs. And these settlements have been based on things of just receiving payments for processing and handling fees related to blood collection, like the settlement I discussed earlier, free point of care test cups, etc., for their lab referrals. The recommendation on the lab arrangements: scrutinize the arrangement, beginning with the amount of your investment if you're a physician, what are areas that you could potentially be receiving remuneration for your referrals to a particular lab, whether it's cash or it's possibly relieving a financial obligation of your practice. For example, putting employees in your practice, assisting with things that relieve you of expenses. Those are all things that a whistleblower, one of your own employees, partners, or other individuals can complain to the federal government and include in a whistleblower complaint. The next point on the state, I talked about physician compensation, and we mentioned that. We'll go ahead and go to the next slide. The first point I want to make on trends in healthcare fraud enforcement on this slide is there is a lot of cases that we are seeing dealing with Medicare Advantage patients. And I think that's primarily because there are so many Medicare patients now covered by Medicare Advantage plans around the country that obviously when that's a bigger part of the healthcare dollar, there's potential for fraud and abuse, as well as investigations on those services provided to Medicare Advantage patients. So one of the cases, for example, there was a settlement in California with a company and physicians where the allegations were the physicians had provided false information regarding those patients and the services and their background to increase the risk scores that when that information, if you're familiar with this, is reported to the Medicare program, it increases the risk scores on those patients and thus increases the payments to that Medicare Advantage plan and to downstream, hopefully to those physicians. However, if that information is not correct, there have been several whistleblower cases brought on that point alone. The next point on this slide deals, we want to go back. I've got two more quick points. The next slide deals with physician-owned distributorships or pods. I want to say, if you're familiar with this, this is our physicians, where physicians have an ownership interest in a company that is a distributor of medical implants. For example, several neurosurgeons or orthopedic surgeons, this is a common practice around the country, have an interest in a company that may manufacture an implant or distribute them, or they may purchase the implant, as, like for example, a spinal implant from a manufacturer, and they may use those in their surgeries and hopefully sell them to other hospitals and health systems and physicians to utilize. The government has consistently taken the position they don't like these arrangements. That doesn't mean that they're not legal. That doesn't mean that you can't do them. But the investigations have centered around whether there's medically unnecessary services or surgeries, utilizing the implants by surgeons and other physicians obtained from companies that they've had that they have an ownership or financial relationship with. I highly recommend doubling down on documenting the medical necessity and of those services and the procedures when you utilize your own implants. And of course, it helps that you sell implants if you have an interest in the company to as many other physicians as possible and not just to the physician investors in that particular entity. Now, the final at the bottom category of trends that we see, and I'd recommend you incorporate this in your discussions and compliance practices, is dealing with healthcare investors that are not referral sources, not other physicians, for example, private equity companies. There was an investigation last year that resulted in a settlement with a company in California called Patient Care America. They paid $21.36 million to settle these allegations. You'll see in the point on the slide, the $21.36 million was paid for. That settlement was contributed by not only a company, but two of the officers of the company and the private equity firm that managed Patient Care of America on behalf of its investors. The allegations, I don't go in detail on the slide, but they dealt with trying to generate referrals for skin creams, compound creams, and other types of products that were primarily sold to patients covered by retired military by the TRICARE program and also Medicare patients. So in sum, before I turn it to my partner, Catherine, I'd like to say from a compliance viewpoint, I would continue to double down and have in place on a documentation process for documenting why you go into a particular arrangement, documenting the medical necessity for the services. Thirdly, have a valuation, whether it's informal appraisal or valuation or a formal valuation opinion in compensation relationships, and keep copy of those. And of course, use a experienced healthcare attorney in your transactions. And I would always recommend not relying on the other side and the attorneys they use, because they are protecting the other side's interest in that transaction. Now for the exciting and the fun part of our presentation, I present my partner, Catherine Murray. Thank you.
Good morning. I know it's hard to get up at 8 in the morning and listen to a seminar, especially if you've been doing it for more than one day. I appreciate everyone's interest in this and appreciate the opportunity to speak with you. As Clay said, I do get to do the exciting things. I often make presentations on fraud, waste, and abuse, and usually the reaction is one of being scared of things. And I don't want you to be scared. I just want you to be aware of some of the things that can go on in terms of what I see with typical physician practices and some of the issues that come around in terms of fraud, waste, and abuse. And I'm going to give you some practical tips on how to at least understand what's going on if there is an enforcement type action involving your practice or a place that you work, and sort of protocols that you can have in place when there's contact with somebody who's in enforcement, especially federal enforcement and also state enforcement. So I'm going to go on, say quickly that I'm a former federal prosecutor. I was a member of the Healthcare Fraud Strike Force. I was also the civil chief and as at the U.S. Attorney's Office here in Louisiana. And in that role, I prosecute a lot of False Claims Act cases on behalf of the government. So I have experience in both the civil and the criminal realm. I've actually even done, as a generalist, some medical malpractice defense of government lawyers, federal government lawyers. So I'm well aware of all the sort of different ways that physicians can become into contact with the legal system. But I'll go on now to the next slide, which is enforcement actions in the time of COVID. And I say in the time of COVID, this is really true of any time. I think in COVID, it becomes, as any crisis, and I say crisis in which you have an infusion of federal money, you have a little bit more audits going on and actions by the government to check what is happening with the money. So although what I show in the slide happens all the time, it's something that I think gets highlighted when the government is in high gear for enforcement. So there's three different ways the government's going to check to see if the money that it gave, and I say gave loosely, either because it's reimbursing somebody for services rendered, such as medical services, or it's a grant or a loan that it has given in response to a crisis or just a business loan. In this case, we have, during COVID, we have both grants and loans that become grants. We have the CARES Act, which is something that is giving monies to healthcare providers to cover, generally to cover any losses sustained or money spent in the prevention, detection, and diagnosis and treatment of COVID. And then you also have the Paycheck Protection Program, which is also being used by some healthcare practitioners and some physicians to cover salaries that are lost because of COVID. So you have, and both of those, well, CARES Act is simply government grants, it's free money, and then the PPP is loans that can be converted into grants because part of those loans are forgiven. We'll get into that a little bit later, but those are monies that are basically given, they're extra grants. So you're going to see a ramp up in enforcement action. We saw it particularly after the Hurricane Katrina fraud in Louisiana. It was going on forever, and there was a lot of it, a lot of enforcement. So how do actions begin from the federal point of view? And that's where I want to talk about from the feds, where I was at one point, so you can understand a little bit the federal world or even the civil world, the state world, because the state enforcement, most states, and all states are different, but most states have similar enforcement mechanisms as the federal government. Medicare and Medicaid will both have the state Medicaid fraud control unit has its own investigators, and the federal government has its own investigators for Medicare fraud, and there's a lot of overlap and cooperation. So you have your traditional, and most people are familiar with this because most medical practices who do any government billing are audited at some point. And you have the audit and overpayment. That's at the agency level. They can go and request a random sample of documents. They look at it. They say, hey, these are good, these are bad. If there's contested, you will have administrative review, which are often successful for the provider. And that's all done as sort of a control. And we're looking at mistake-based, not lying, cheating, stealing, but you just billed this wrong. This wasn't reimbursable. This wasn't signed. This document that needed to be signed within a certain amount of time was not done. And usually it's fairly straightforward, very common. And that will done, usually initiated by a letter of some sort. Sometimes an agent will come with the door with an audit, but a lot of times it'll be done through letter, through communication with the compliance officer. That can stay there and just stay as an audit. Sometimes if the auditor finds something they don't like, they can refer it out to a prosecutorial branch like the U.S. Attorney's Office or the Department of Justice. The next level is a Civil False Claims Act case, a civil fraud or civil false claims case, which is Clay's already talked about. I'll talk about a little bit more in detail. These are cases in which it's beyond the overpayment the level of audit, and you're getting into a material false or fraudulent statement in the submission to the government, which can be a loan application, it can be a claim for payment under Medicare, TRICARE, or the government programs, or grant application, what have you. And the government contends it was false or fraudulent, it would not have paid that, and it's entitled not only to get paid back what was paid, but it's also entitled to certain damages. It's usually, and this is important, brought by a whistleblower. We'll talk about that a little bit more in a second. But the government can also initiate a claim if it has indication of wrongdoing. And I did both. 70 to 80% of these claims are initiated by whistleblowers, but there is a certain point that is not. The third one, and hopefully we'll all stay out of this, is the criminal action. That's also started by complaints, it started by audits, and they see lying, cheating, stealing by the government. This is more extreme form. This is where there is a scheme or artifice to defraud, which means there is an actual intent and a plan to just steal money from the government. That's the layman's term. There's a nice legal term for it. That is the low-hanging fruit. If you have a fraud company that's set up as a fraudulent company, they have a storefront, and they can't have a storefront, and they're not really doing anything but just selling fraudulent claims. Then that's going to be an easy low-hanging fruit. I'll get into a little bit. I'm not going to concentrate as much on criminal actions. I don't believe that's an issue here, but civil and criminal, there's a fine line. So you always have to be concerned when you are having a civil fraud investigation, there might be related criminal action. A lot of the Civil False Claims Act also began as criminal actions that the government just doesn't decide that it has quite enough proof to show it's criminal, and they just go with the civil fraud. So let's go on to the next slide, please. And I'm going to talk about the False Claims Act, what it is. This is, the False Claims Act is a federal statute. The main elements are you have to have a false claim, and it doesn't have to be false in the sense that it's, you said it's black and it's actually white. It can be false because you certified to the government that you met a condition. For example, when you submit a claim for payment under Medicare, whether it's knowing or not, there is something you sign that said, your Medicare provider agreements and also with every claim that says, I certify that in submitting this claim, I have complied with all federal laws, including the stock law and the anti-kickback statute. So if you have committed a violation of the anti-kickback statute that Clay was talking about earlier, and you submit the claim, you're saying, hey, I was in compliance. That is a false claim. The underlying claim for payment that you treated somebody for some condition may not be false at all, but it's false because you certified that you complied with certain conditions and you did not. This is very important when you start talking about this loan fraud and this grant fraud. That's what it's about. You are certifying I am in compliance with all the loan or all the grant requirements, and I'm in compliance with federal law. If you are not, then that claim is false because you falsely certified to the government that you had done certain things that you had not done. The falsity has to be material. It can't be, pick a unit. It can't be, I put the wrong address, or I made a mistake in a code and one claim, and it should have been this or that. The doctor's number was inadvertently put in wrong. I mean, it has to be a material. Did the government get what it bargained for? Would it have paid the claim even if it had known of the falsity? That's pretty much what the courts are coming down to when they're looking at how big a deal is that. Because there's so many, as you know, as physicians, there's so many requirements. There's so many things you have to do to be in compliance with all the federal statutes, healthcare regulations that, you could be, every claim could probably technically be false, but it has to be material to the government's decision to pay. One thing that's really important is that you don't actually have to get the money to be liable under the False Claims Act. When I was prosecuting False Claims Act cases as a federal prosecutor, federal attorney, sometimes I would go after the person who caused it to be filed. For example, if there was a bank who helped a person who was getting a government loan falsify or fudge documents or suggested that they do certain things, they didn't get the whole $1 million loan that we're investigating, but they did cause that loan to be submitted by helping this lender this borrower who otherwise would not have been qualified for the loan to get the loan. And they're going to be on the hook, they being the lender who caused the borrower to, submit a false loan application to the United States. They're going to be on the hook. The bank, in other words, is going to be on the hook for the whole amount of the loan, even though they didn't profit that much. So there is, and you'll see this in the False Claims Act cases, that they are looking at a wider net of people who participated in the fraud, even if they did not personally profit from it. Next slide, please. This is I'm going to go probably really quickly. What is the level you have to know that's false? You have to have actual knowledge that the claim is false, or you have to act in deliberate ignorance of the truth or reckless disregard for the truth. So if you're just turning a blind eye, I guess is the best way to say it in layman's terms, there's everyone around you is kind of swirling with this, or there's rumors, or there's, the paperwork doesn't look good, and you're like, I don't want to see it, just file it anyway. And somebody can testify that you said that, then that's probably going to be enough. You just, it was all there. You were signing things but not reading them, and it was there, then you're going to be in trouble. Real important on this slide, probably the most important for today's purposes, is the failure to remit an amount owed can be the basis of liability. So everybody knows that medical billing and coding and all of this is very complex, very difficult. Mistakes can be made. But if you discover that you overbilled the government, maybe because of a coding error or what have you, and you're having under obligation to disclose that to the government within a certain time period, within 60 days, your failure to disclose it can be the basis of False Claims Act liability. And when we're talking about in the time of COVID, you have grant money and loan money that people are applying for. I say grant money, it's basically grant money, free money and loans that people are applying for before they even know how much they need, because we're at the beginning of an epidemic and the beginning of a crisis. Well, they can overestimate, they can get things wrong. And that's not really going to go against them as long as they don't say at the end of the day, hey, I've got this extra, $500,000. I told the government I needed it. I don't. I'm just going to keep it and use it, find a way to hide it and use it and survive an audit. No good, no bueno, as they would say. That is not what you want to do, because that is in itself a False Claims Act violation, and it can become even more serious if there's a pattern of it with different funds, or you had the intent, they can prove that you had the intent to do it from the beginning. And that's important all the time, but especially in the time of COVID, you have to remember the 60-day rule. Next slide, please. The most troubling thing about the False Claims Act cases from a physician or a healthcare practices point of view can be summed up in one word, and that's the whistleblower. And the False Claim Act works like this. The government can bring a claim and say, sue a practice and say, hey, you wrongfully, false and fraudulent claims to the government for payment because you bundled or unbundled these certain things and billed them separately, and it was, or you upcoded, and there's all kinds of different things, or these services were not medically necessary, and you documented as if they were. There's a lot of different things that the government can do, but the government does not always have a lot of resources or the inside info to get the information of who is actually committing these sort of violations. So they rely greatly on what they call a whistleblower, and the legal name for whistleblower is called a relator. So you'll see that on the slide, relator. So the relator is somebody, and almost always, and I worked with relators both on the government side, and I work now with them. I defend healthcare physicians and healthcare practices in these cases. And both can, it's the same. I can usually guess who the relator is on the other side. They're usually disgruntled employees. And so these disgruntled employees, or sometimes they're competitors, but they're usually disgruntled employees. Somebody's had an insight in there. They say, okay, I found this fraud. I'm going to go find a lawyer, and we're going to file a case under seal, which means it's not available to the public. You can't find out about it. The government, and this is important, the government has an obligation to investigate that. So even if the government initially thinks this is maybe not something I want to do as a prosecutor, this isn't like a big case for me, under the False Claims Act statutes, the government has to. So the government has no discretion to say, hey, I don't want to take this. It's not a good case, not a lot of money. And then, the relator works for the government to develop the case. And even if the government decides, hey, we're not going to do it, the whistleblower or the relator can go forward on their own. What is in it for the whistleblower? And you can see it's 15 to 30% of what the government gets. And if there's a $3 million settlement and you're getting 15 to 30%, that's a nice little chunk of change. And the whistleblower, again, worst part about it is it forces the government to investigate. And the government can investigate without you knowing it by interviewing former employees and using records, ways to get records that you won't find out about until later, bank records and the like. They can investigate 2, 3, 4 years before you're even aware the investigation's really going on. So it's a real problematic thing for everybody, especially for the defendant in these cases. Next slide, please. Another real big problem with the False Claims Act is how long it lasts. It lasts forever. The statute's a little convoluted, but I can say the government basically has up to 10 years to bring the action in court. And then the investigation stage can last even longer. So you could have a disgruntled employee who's not disgruntled, and there's some retention of funds that perhaps shouldn't have been retained. 3 or 4 years later, that employee becomes disgruntled, doesn't get a promotion, something happens, they leave, they file a False Claims Act claim 3 or 4 years later. And then, 7 or 8, 9 years later, you may find out about it, or the provider finds out about it, and then memories are often difficult, witnesses are difficult, and the damages you face under these things are so great that most of the time forces people, a lot of the time forces people into position of settlement, which is, again, just not great for the provider. So these are the gifts that keep on giving. Your disgruntled employees, your people who are always griping that there's something going wrong and you need to take care of it and you're doing this wrong. Those are the big kind of red flag, bells above their head Be careful in how you answer their concerns. Show them that you've done things the right way, because they will be the whistleblower of the future. And if you've documented that you investigated and you were able to show that this was that, you're in good faith when you go to the government. Next slide, please. I want to show why this is important. This is just an example. This is dated June 3rd, 2020. This is a few weeks ago. It came out. It's a Department of Justice news release. It's a news release that deals with a fraud recovery under the False Claims Act. It is hurricane relief fraud from Hurricane Katrina, which happened almost 15 years ago. So we are having settlements, False Claims Act settlements for grant money fraud from Hurricane Katrina in 2020. Are we going to be having COVID fraud-related cases, civil fraud-related cases being settled in 2035? It's possible. So this is the gift that keeps on giving in terms of exposure. That's why you have to be very careful. Next slide, please. This is the penalties. The penalties under the False Claims Act are up to treble damages. So if they find that the government finds that you wrongly billed $2 million, then it's $6 million plus a statutory penalty for each claim to the government. So each time you file a claim for reimbursement, they're up to about 22,000 max, I think between 13 and 22,000 per claim. Usually the government will only impose one or two of those. Joint and several liability, personal liability on the people who actually did it, and it's enforceable judgment that generally survives bankruptcy. Next slide, please. So I was asked to, and I think it's important to tell you this, and this is something I talk about a lot. What do you do? What is your contact with enforcement? As physicians, and I know that y'all are physicians from different states, I know that there are different ways that you can enter into a legal process. You know, service process, you have to have gotten subpoenas, notices of depositions, that sort of thing, just for, as treating physicians in cases, injury cases, God forbid, a malpractice case, workers' compensation cases, things of that nature. But in terms of enforcement, what are you going to see? Well, first of all, if you get a letter from the government asking for things and it's mailed to you, certify however you do, it's that's usually just an administrative thing. That's not your issue. When you have someone showing up and serving you a subpoena, that's when it gets real, especially if that person who comes up and shows a subpoena is not a sheriff or someone who typically may serve a subpoena in your jurisdiction, which you should be used to because you're going to get subpoenas as doctors. But if it's someone who comes in and shows an ID, which most agents are supposed to do, and their name has special agent on it, that means they're investigating fraud, waste, and abuse. Special agent is an agent who generally, they're all special agents. That's just that they're not special because they're special. That's just the title, special agent. I first started working with the FBI. We said special agent. No, they're all special agents, okay? So you have special agents for HHS-OIG, Office of Inspector General for HHS, FBI, DEA, Social Security. These are some of the people you might see. SBA, Small Business Administration. So special agent or civil investigative agent, those are people who are looking at enforcement actions. They will generally show up and serve you something in person. It may be a subpoena. It may not be called a subpoena, okay? One of the things that they like to do is talk to people when they do it. So you'll have special agent John Doe come up, and he could be coming with, and I'll show you, administrative subpoena. An administrative subpoena gives a agency the ability to go request documents. I want these 30 charts or 30 patient files, what have you, some sort of random sample. They will ask for it in person. They may ask you to copy it at the moment. They don't want you to, and that means they don't want you to start falsifying anything. They don't want you to start, if you say, I just don't have it, like, okay, we'll come back, we'll you know, tell me when you can produce it. It could be a civil investigative demand. If you see the word civil investigative demand, that means there is a False Claims Act investigation going on. Whether or not you're the target of it is a different matter. Whether or not you're the target of investigation when there's an administrative subpoena is another matter. An administrative subpoena means that they're either doing both a civil investigation, a criminal investigation, or both, but they don't want you to know what they're doing, so they're just starting. It's usually a very preliminary thing that they do. So civil investigative demand will tell you on its face, this is a False Claims Act information. The third one is a grand jury subpoena. A grand jury subpoena is a criminal. It can only be used for criminal. Now, the fact that you get any of these three does not mean that you are necessarily a target. Many times the prosecutors will use these tools to get third-party information. It could be that you get a grand jury subpoena because you may have records of a doctor that used to work with you who was falsifying timesheets somewhere else, and they want to show that he was falsifying timesheets somewhere else because he's actually working for you at that time. That would be relevant, but you're not on the hook if you didn't know about it. So, they just want your records and they'll give a subpoena. A lot of times they will tell you you're not the target or the subject of the investigation. They are key words. Subject is you may be, we don't know. Target is we're the ones you're looking at. Whatever the case may be, the most important thing for you to do is twofold. Have a protocol in place for the people who are going to be receiving any kind of process, which is usually your front desk people, on how to respond to it. Because agents love, and as a prosecutor, I'd send them out in the street to say, see if you can get them to talk about something. You start chatting up and being real charming. Oh, you're not in trouble. It's not you. And they can lie to you. You can't lie to them, but they can lie to you and tell you, oh, we're not really looking at you, or, it was just a routine investigation. Don't know. Just if someone shows up at the door and they have a badge from some government authority, you are only authorized to accept whatever they give you, say thank you, get the business card of the agent, which they will give you, and they generally are supposed to give you, and then say thank you very much. I'll refer it to the person in this office. Okay. Then once you get that document, unless you are pretty certain that that document is something for some civil suit that you already know about, or it's some routine civil inquiry for documents, then you really need to probably look at it and contact an attorney. Do not, with a grand jury subpoena, I would never recommend going to a grand jury producing documents, but at least having that grand jury subpoena vetted, because a lawyer can call up the agent or the assistant U.S. attorney and the prosecutor and say, hey, is this just a third party? What do we need to do? So those
just to let you know, 4 minutes left.
Yeah, I got it. Thank you. So that's the basics of where we are in terms of how you should handle it. Have a protocol in place, be able to understand a little bit the differences of what kind of process you have, and realize that talking to agents is never a good idea until you talk to your lawyer. The last couple of slides that I have, these are mainly, and they're really only about 3, these are showing just the different things that can happen in times of COVID, what people are going to be looking at. It's a little bit repetitive of what Clay's done, so I will just say that everything that I've talked about here applies during COVID. These slides give you an idea of some of the things that we anticipate seeing in terms of claims going up in the future. Other than that, are there any questions that you might have of us in the very few minutes that we have remaining?
Thank you very much for the succinct and to the point presentation. There is actually a question, and that is, what about the complex legality and the maze created by the government, where physician can easily get entangled or trapped? They are asking for any suggestions or comments from you.
I'm sorry, I didn't understand the first part of the sentence.
What it says is very informative legal information for the practicing physician. Turning the table around, what about the complex legality and the maze created by government where a physician can easily get entangled? Any comments or suggestions?
I will just say, I think the best thing that you can have is somebody who's really good at compliance, and that you have a good compliance officer and take it seriously, because one of the best things that the best defenses in these actions is having a real compliance program, and one that is monitoring, one that is self-auditing, one that is making sure that the claims, the best of its ability, is being done, and that any complaints internally are being vetted and investigated. If you show a pattern of that, 9 times out of 10, you're going to be in good shape with the government, because the government understands that things can happen. What they want to see is people trying to do the right thing. Clay, what do you say?
Yeah, and I just want to recommend to that question, there is a myriad of legal responsibilities that physicians and others can not realize are there and trip into. I would recommend, trying to structure your relationships financially wise or otherwise, your service relationships within a safe harbor exception to the statutes that apply. And if you're getting legal advice, you're laying out all your efforts to be in compliance and to make your best effort. And that's your discussion. Because you're not expected to know, or at least I say that, you're not expected to know the myriad and hundreds of statutes and regulations that apply, whether it's through the HIPAA regulations or the fraud and abuse or the Medicare coverage requirements, but make efforts to make sure you're in compliance on a continuing basis and have your staff educated. That's really the best defense to hold out.
Thank you. There are two more questions we can take. One is this related only to the CARES Act or PPP claims or any general investigations?
Any general investigations. I said the CARES Act and PPP because that's what we have right now. I just foresee that's going to be the focus of the government in the next 10 years, especially civilly. But what I said today is standard operating procedure. This is the way it always works in the enforcement world. I will also say that you're going to see a lot more enforcement personnel for the government. They're going to have a sort of a strike force and task force set up to deal with the COVID and PPP fraud, which will be a lot of their focus. For them, it's the low-hanging fruit. They know who's gotten the money. It's easier to go after.
Yeah, so I would just emphasize the same. It's going to continue. And there's other areas, like we didn't talk about the proposed changes to the Stark Law and the anti-kickback statute that came out last October regarding value-based arrangements. We think that will pick up again soon to encourage those. And so the same compliance steps of documentation, reviewing the applicable regulations as they evolve, and making sure things are within the fair market value are the best steps that we can recommend that a physician takes.
And then the last question, what's your estimation, how much waste, fraud, and abuse is in our healthcare system?
That's hard. I don't know.
Unfortunately, there's probably a lot.
There's a lot.
Where there's money, there's issues. So that's where you can outshine others in your business practices. But unfortunately, there's probably a lot. We've already seen it with the funding and some of the charges related to, the stimulus funds and the SBA and the PPP loans.
We already have criminal cases already. As of May, they were already bringing criminal cases for the CARES Act fraud, immediately. I will say, it's hard to tell because so much goes undetected. But from the government standpoint, they have an idea. And I've talked to HHS, OIG, investigative, civil, criminal fraud investigators. They think it's like 75, 80%. I think that's crazy. But if you hear some of them talk, they think that, three providers out of 4 are fudging it somehow. I think that's crazy. I would argue with them. But the important thing to remember about government investigators, not prosecutors, we're the sort of line of defense against a lot of it, but the investigators they're gung-ho. And so the government tends to see fraud, waste, and abuse where it isn't. So that's why documenting everything is important. It's impossible to say how much there actually is, but the perception of how much there is, I think on the private sector and for the physicians, I think you would see it as a low figure. The government sees it as very high. I think it's probably more on the physician side, but I think there's a good, I don't know how much I want to say.
Yeah, and the one thing I would add is, I've talked to several physicians who have said, I checked my bank account and I got money in the last few weeks. There was a big deposit from the Medicare program and I didn't even know I received that money, which is great news on one hand, but on the other hand, always recommend be aware of the relief and the stimulus money and that's out there, because there are several people who have not received it that want to receive it. but also when you receive it, make sure you're complying with the restrictions, any documentation, so you can keep the money and don't have to deal with issues down the line. And we appreciate going through these fun and exciting topics on a Saturday morning.
Thank you very much.
Hopefully this was helpful.
Great team presentation.
And we look forward to Melinda and her group talking on their presentation.
Good. You are welcome to stay. The next presentation is on the preventing harassment in the workplace. And the speakers are Melinda Malecki and Anthony Ashenhurst. Both are JD, and they belong to Malecki and Brooks Law Group in Elmhurst, Illinois. The platform is yours, Melinda.
Thank you. Good morning, everyone. We thank you for inviting us to speak here today. We're very honored to be part of this program. A special thank you to Dr. Murthy for inviting us. Malecki Brooks is a law firm based primarily in the Chicago area, and we concentrate in physician representation. And as a part of that, we do this training mostly because we believe in it, but we also realize that it is required as a risk management tool for our physicians and their practices. So at this point, I'd like to introduce Tony Ashenhurst, who's going to start out.
Thanks, Mindy. Like Mindy, I appreciate the opportunity to be here. Like Mindy, I do this and have been doing this for over 20 years because I believe in it. I started many years ago with a large law firm, national law firm, training Ford Motor Company employees all over the country. I did it because I believed in it then, and I believe in it now. And also we have some legal ramifications that have been extended that didn't exist even 20 years ago. The basic premise to all of this is that you go to work to work. So does that mean, gee, I can't talk to anybody? It's just all business? I can't say hello, can't talk about what I did over the weekend? No. It means you're going to go to work and you're going to do your work respectfully when interacting with other people. Respecting people and is paramount to providing good medical service. There is a ton of literature that shows that disrespect, harassment in the workplace leads to medical errors, and it leads to turnover, and it leads to very unhappy employees. You know, no one wakes up in the morning and says, man, I can't wait to get to the clinic, or I can't wait to get to the hospital so I can be disrespected. I really like that. Nobody does that. Everybody expects respect, and they should. I mean, that's what we are all entitled to. And one of the things that I think hits home with a lot of people is, how do you want to be treated? And more so, how do you want your partner, your spouse, to be treated? What do you expect your children to face when they go to work? So it's just a matter of respecting everybody you work with. And that's what the basis of these harassment prevention trainings are all about. So we're all on the same page. The purpose of our training today, as you can see on this slide, is that we'd like to help change behaviors and attitudes, educate you about the law, educate you about what is expected, provide an opportunity to examine behaviors that may occur in the workplace, educate you about the rights if you believe that you are a victim of harassment, or if someone else in your practice believes they are, and help you understand what legal remedies exist for their protection, to stop harassment in all its forms. And honestly, as Tony said before, it's because we think that it's the right thing to do. When we talk about harassment, there can be a lot of circumstances in which people feel they're being harassed. However, when we're talking about harassment in the context of this training, we're talking about harassment based upon a person's membership in what is called a protected class. How do we know what a protected class would be? Well, we have to look to federal and state law to make that determination. The laws that govern harassment are several federal laws. Virtually every state has its own laws that govern harassment and respect in the workplace. As far as the federal laws go, we begin with the Civil Rights Act of 1964, and that prohibits discrimination based upon race, national origin, color, religion, and sex, including pregnancy, and pursuant to a recent Supreme Court decision, lesbian, gay, and transgendered. That's the Civil Rights Act of 1964. So it not only prevents discrimination based upon those protected classes, it also prohibits harassment. We also have the Age Discrimination in Employment Act, and that protects people that are 40 and over from being discriminated against simply on the basis of their age. We have the Americans with Disabilities Act, which likewise prohibits discrimination against someone because that person is disabled when that person can, with or without a reasonable accommodation, be able to perform the essential functions of their job. We have the Uniformed Services in Employment and Reemployment Rights Act, and that protects military, active military, as well as veterans. And for those employees that may be working in some government agency, be it a government hospital, a government clinic, we have certain protections under the First Amendment, which basically says that if you are free to express your concern about something of public interest within the hospital, within the clinic. Again, that only applies to public employers. So harassment based upon membership in any of those protected classes is illegal under, as I said, under federal and most state laws. Now, generally we do this training live, and we are present, so I can ask questions and people can raise their hands. And at this point, I always ask, who here in the audience is not a member of a protected class? Just go ahead and raise your hand if you're not a member of a protected class. Invariably, I get a couple of people that raise their hands. But the fact of the matter is, we are all members of a protected class. How is that? Well, nothing else. We all have a gender. We all have a sex. And these laws apply to me as a white male, as well as they apply to a white female, or someone of color, or someone who has a different religion. So everyone is a member of a protected class, and everyone is covered by these anti-harassment laws. We're going to talk about what happens if there is a complaint of harassment, but I want to digress here just for a second to talk about those agencies that actually enforce the laws that I just mentioned that create these protected classes. The federal agency is the Equal Employment Opportunity Commission. That's the EEOC, and that was created under the Civil Rights Act. Most states have their own laws and agencies that enforce these laws. In Illinois, it's the Human Rights Commission. They have a process by which they will investigate through another department called the Department of Human Rights. But ultimately, it's the Human Rights Commission that would be the final decision maker. I want to note also that on January 1st of this year, Illinois enacted a law that requires every employer to provide sexual harassment prevention training at least once a year to all existing and new employees working in Illinois. So if you're an employer, you do have an obligation to provide harassment prevention training to your employees, and you have to certify that you've done that. And even if you work for an entity that is from another state, if you're registered in another state or you're incorporated in another state, as long as you have employees in the state of Illinois, you are required to do that. Some states, and many states have that requirement now, some states even have requirements that you have a sexual harassment or a harassment prevention policy. Illinois has no such policy unless you're a bar, a restaurant, or you're a government contractor. For those of you that may then have government contracts, you would be required to have a harassment prevention policy. And if you happen to be running a bar or restaurant out of your clinic or your hospital, you're going to have to provide that training also.
So what exactly is the definition then of harassment? So the EEOC, as Tony mentioned, defines harassment as an unwelcome conduct that is based on race, color, religion, sex, including pregnancy, national origin, age, 40 or over, disability or genetic information. Harassment under the EEOC definition becomes unlawful where a person is enduring offensive conduct becomes a condition of continued employment. That's called quid pro quo harassment, which we're going to discuss shortly, or the conduct is severe or pervasive enough to create a work environment that a reasonable person would consider intimidating, hostile, or abusive. Anti-discrimination laws also prohibit harassment against individuals in retaliation for filing a discrimination charge, and Tony will talk later about what retaliation might look like, testifying or participating in any way in an investigation, proceeding, or lawsuit under these laws, and opposing employment practices that they reasonably believe discriminate against individuals in violation of these laws.
As Mindy said, quid pro quo is a type of harassment. And that's when, as she said, it's this for that. That means that someone with authority over another person in the workplace says, look, if you want a raise, if you want a better shift, if you really want to make it in this corporation, then I think you and I need to have a sexual relationship, or make some kind of hint that that's what it is. Likewise, look, if you want to keep your job, if you want to get a raise, then you're going to have to play ball with me. Again, that's called quid pro quo sexual harassment, which literally means this for that. You give me this, I'm going to give you that. That is, per se, as a matter of law, illegal harassment. Now, a couple of things about quid pro quo harassment. First of all, it only applies to sexual harassment. I mean, it only makes sense. How can you trade someone's race or someone's religion for a better job? It is asking somebody for sex in order to better that person's position or to save that person from losing that position. And it only applies to two people that have different power. It has to be a supervisor who has power over the other person. One employee that doesn't have power over another employee, just a coworker, cannot commit quid pro quo sexual harassment because that person can't offer anything. If the person doesn't have any power to give a raise or power to keep somebody from losing his or her job, then it can't be quid pro quo sexual harassment. Also, one of the things you always must keep in mind is when somebody is in some form of management position, it could be a physician owner, it could be an office manager, it could be an executive director. Anytime someone with supervisory or management authority does anything, the organization is deemed under the law to be aware of it, because someone in management authority is the organization as far as the law goes. And we're going to talk about the importance of notice and the impact of having notice of harassment in a couple of minutes. But the employer always is considered to be on notice when there's a quid pro quo sexual harassment. So what is the other type of harassment that Mindy mentioned? Is hostile work environment harassment. And many times that's the most common. I mean, in today's world, even though it still happens, people have to be pretty emboldened to suggest that if you give me some form of sexual favor, then you're going to get a better raise, or if you don't, then you're going to lose your job. Hostile work environment sexual harassment is when somebody makes the work environment so bad that a reasonable person cannot do it without feeling hostility. And it can be created by a supervisor or a manager or an owner, even without quid pro quo. Again, if it is by any of those people, the organization is deemed to be on notice. But it can also be in a hospital by a visitor, by a patient. It can be by some form of independent contractor. It can be by a drug rep. It can be about anybody who comes into the workplace or has some connection to the workplace that is in a position to make an employee feel uncomfortable and feel that the work environment is hostile. So some examples are, as you can see on your screen, very typical: calling people names, sexually suggestive comments, sexually suggestive compliments, dirty jokes, offensive pictures, offensive clothing, touching. And also, I need to mention touching, not only does it constitute sexual harassment, an offensive touching is actually a crime in every state. It's called a battery. So when somebody does that, and I have been involved in situations in which people have been what we call groped in the workplace, that is a crime. And anybody who does that not only would be subject to whatever ramifications in employment may be, but also could be subject to arrest. None of this has to actually occur on the work site, in the office, in the clinic, in the hospital. It can occur off. It can occur by, as it says, social media. It can occur at a social event. It can occur at somebody's backyard. Although it didn't take place in the workplace, if it somehow makes it back into the workplace, that makes the victim of that feel uncomfortable, because it is now a hostile work environment that's been created at the workplace, it is harassment, and it violates the law and should violate any policy. And we will reiterate through this: every employer, whether it's mandated by law or not, should have a policy. Can you increase the volume? I just got a note that they can't hear me. Okay, I hope that's better. I want to point something else out too. Although the EEOC, as many dedicated, has defined harassment, the EEO also says, and you see this on its screen, petty slights, annoyances, isolated incidents, unless extremely serious, will not rise to the level of illegality. The test is whether the conduct, the alleged harassment, is severe or pervasive. Somebody can tell an off-color joke, a dirty joke, or we would call a dirty joke. That isolated event may not constitute what the law would consider, what the courts would consider, what EEOC would consider harassment, because it only happened once. It's an isolated incident. But if that person tells a joke over and over and over again, at that point, even though once it's isolated, it's not severe, it becomes pervasive. And at that point, it can be considered under the law illegal harassment. And it must create a work environment that's intimidating, hostile, or offensive to reasonable people. And we will look at the reasonable person standard. We're not looking from the standard, the standpoint of the person engaging in the behavior. We are looking from the standpoint of the person that has been subjected to that behavior, whether that person is a direct victim or somebody that just witnessed it. Because even though you may not be the direct victim of harassment, if you witnessed the harassment and you were offended by it and felt that that was creating a hostile work environment, it is still illegal harassment and still would violate a properly drafted policy. Right, but I have to say, there are some circumstances in which isolated events would be considered severe. And that would be in the case of racial jokes, racial name calling. That only has to happen once. And the EEOC and the courts will generally say it only happened once, but that was severe. It didn't need to be pervasive. So what kind of conduct can constitute harassment? We've kind of gone over this before, but what do you find in the workplace generally? Offensive jokes, racial slurs, religious slurs, slurs on national origin, name calling, physical assaults or threats, which again constitute a crime, intimidation, ridiculing somebody, and just insulting somebody, but it is based upon their membership in a protected class, offensive pictures. You know, that happens a lot. Like I did a lot of training for Ford Motor Companies. I said, you know, you'd open up a locker and the locker room and there'd be some offensive picture there. And just interfering with work performance because that person is a member of a protected class. Again, we reiterate a lot of things in this training. A harasser can be the victim's supervisor, and that person can engage in hostile work environment harassment, but it can also be a person engaging in quid pro quo sexual harassment. It can be a supervisor in another area. Again, to reiterate, if this is a supervisor doing it, the organization is on notice. It can be an agent of the employer. It can be a coworker. And as I gave examples of, it could be a patient. It could be a family member. It could be an independent contractor. It could be somebody who's calling on the hospital, the clinic, to provide a service, any non-employee, regardless of that person's relationship, if it does create that hostile work environment at work. And as I said, it doesn't have to be the person that is the victim of that harassment. It can be somebody who witnessed it, that was offended by it, reasonably offended by it, and felt that that creates a hostile work environment. And there doesn't have to be any injury to that person from an economic standpoint, but it has to create a hostile work environment. As the next slide is just a reminder, because there's sometimes this confusion about quid pro quo sexual harassment and hostile work environment harassment. Harassment based upon membership in a protected class other than sex can only be a hostile work environment. It can never be quid pro quo sexual harassment. So let's digress here a second and let's just look at a few examples of some behaviors. And you can see this, and again, we need to be able to categorize this somehow. So we're going to use the stoplight analogy here. We have a red light, which means bad, a yellow light, proceed with caution, a green light says okay. So we'll look at these behaviors. You just think which of these behaviors would fit in which category. So the first one, Dr. No, in order of the practice, sees Pat in the hallway of the clinic and says, "You look very nice today." Where does that fit? Is that red? Is that something you never say? Is it something you proceed with caution? Or is it okay to say that? What do you think? Well, I think in most cases, people are going to say, there's nothing really wrong with that. If you see somebody and say, "You look nice today," most people are going to think there's no sexual connotation to that. Maybe some people might not like that, but would a reasonable person be offended to the extent that they believe you've now created a hostile work environment because you've told me I look nice? So the next one. Dr. No, an owner of the practice, sees Pat in the hallway of the clinic and says, "You look very nice today. I can't get you out of my mind." Well, you add that, and now we're wondering, why was that added? What did that mean? That's something that can proceed to yellow pretty quickly. And here's the rule of thumb. Before anybody says something, think about, is this something that is fine to say? Is this something that could possibly offend somebody? Or is this something that I should never say? And if you're at, this could possibly be offensive, don't go there. Just like you would never go there if it's something that would fall into the red. A lot of it is inflection too. So if we go back to the last slide, which you don't need to do, but it says you look very nice today, say, yeah, I can say to Mindy, "Mindy, you look very nice today." I can also say, "Mindy, you look very nice today." You know, the inflection, giving somebody the once over, that can take what may be completely innocent words and change the connotation completely. Mindy, is this mine? Lee, a clinic receptionist, is sitting at the reception desk. Lee looks up and sees Pat, a nurse, staring at her. Lee says, "Ask Pat, why is Pat staring?" Pat doesn't respond. Has anybody ever spaced out? Have you found yourself just staring at the wall, at a chair, at maybe another person? You have no knowledge that you're doing it. It is completely subconscious. And when somebody says something like, "Why are you staring at me?" if you don't say anything, it makes the person very uncomfortable. Makes them wonder, why is that person staring at me? Now, if Pat had just said, "Oh man, I'm sorry, Lee, I totally spaced out. I really wasn't even looking at you. I had just spaced out. Something was on my mind." Generally, that will take care of it. And that will satisfy a person, okay, this wasn't sexual, this wasn't something to make me uncomfortable. You just spaced out. Just think about how you respond to something like that.
So building on that one, we have Lee, a physician in the practice, sees Pat, another physician in the practice, at a tavern after work. They have a few drinks and they're discussing issues in the practice, and Lee says to Pat, "Why don't we take this conversation back to my place?" And Pat says, "No," but Lee persists. Pat still says no. The next day at work, Lee won't speak to Pat and will not consult with Pat on a patient issue. So although this situation occurred outside the workplace, it was brought back into the workplace, and it can still be considered harassment.
And that's a really good point. And again, to reiterate, don't think because you're not on the workplace you cannot be engaged in harassment, because that's not true. So the next example, Chris, a black female clinic employee, is telling jokes about how black women like to have sex. Everyone's laughing, no one objects, including Lee, who's also black. Is that okay? There are a couple of issues here. No one owns his or her race. No one owns his or her gender, or religion, or national origin. And what may not be offensive to me as a white male might be offensive to some other white male. Something that might not be offensive to Chris, a black female, might be offensive to a white male, to a white female, to another black female. So nobody can say, you know, I can say anything I want about people in my race, my religion, my gender, because I'm a member of that. Doesn't mean I own it. There's also a concept which is very common in the workplace. It's called go along to get along. Yep, Lee may have been laughing, but Lee may have been totally offended by what Chris was saying. But I don't want anybody thinking I'm not having fun here. I'm just going to go ahead and laugh. So it's very dangerous. This is an example of something that this doesn't come into the workplace. This is red. If you want to tell jokes like this, feel free, but don't do it in the workplace or in any situation that can be brought back into the workplace. In the next example, Chris is telling a dirty joke and Lee overhears it and laughs, says that's funny. Later, Pat's telling a dirty joke and Lee overhears it and makes a complaint to practice management about Pat telling a dirty joke. Is there a defense? Wait a second. Lee overheard that Chris telling a dirty joke and it was fine. But Pat says, now I tell a dirty joke and it's not fine? No, that doesn't make any sense. Lee waived his or her right to complain about a dirty joke. No, that's not true. Lee is free to file a complaint anytime, and it's not an offense that Lee may have said that that's funny in a previous situation. You're going to take it as it is, and you're not going to engage in some form of credibility issue of the person because maybe that person laughed at another joke and found this one offensive or decided to report it. The thing also is, okay, Chris tells a dirty joke, Lee overhears it and says that's funny. But now Pat tells a dirty joke, and Lee may at that point be saying, you know what, there's too much of this going on. This isn't right for the workplace, and complains about it. And that may be what we consider a substantiated complaint. Next example, Chris calls Lee on the phone after work and says, I'm going to get you for filing that baseless harassment complaint about me. You know it isn't true. Let's take, for example, that it's not true, that Lee made this up to hurt Chris. That does not give Chris the right to retaliate against Lee. Retaliation is prohibited, and it doesn't matter if it was true or not true. There's only one entity that can retaliate, and that form of retaliation would be if they found that it was what we will talk about later as an unsubstantiated complaint, and then Lee is disciplined, because that's what the policy does. It doesn't leave it up to individual employees to fix whatever the situation is. And by Chris doing that, Chris has violated the law and has violated the policy, a properly drafted policy, and therefore Chris can now be in a situation in which Chris was initially a victim to now actually be somebody that's violated the policy.
So in the next example, Chris, an owner of the practice, asks Pat, a new physician in the practice, to go to dinner. And Pat says, I'm not sure I should. And Chris says, oh, I think you should. And as a matter of fact, if I were you, I would really think about it. So in this situation, Pat is being pressured to do something that she's not really comfortable with. This could go either way. This could be hostile environment, or it could be quid pro quo harassment.
And the next one, and this is a tough one, and sometimes people don't understand this. Chris and Lee become friends at work and begin dating. They get married. And by the way, many states have laws that prohibit anti-nepotism policies, meaning you cannot fire somebody because that person has a relationship with another employee. But they get married. They're in love and very affectionate with each other. They hold hands during the day when they see each other, and as well as hug and kiss when they pass in the hallway. It's completely consensual because they're married to each other. This could constitute hostile work environment sexual harassment. How could it? Well, there's several ways. First of all, many people are very uncomfortable with people showing a tremendous amount of affection around them. Many times it's cultural. Many times it just makes people feel uncomfortable from a sexual standpoint. And therefore, it's not appropriate. You know, the adage is, take it home. Be affectionate with each other someplace other than the workplace, because holding hands, being affectionate, hugging and kissing don't have anything to do with your job, so you don't need to do that. You can do that after work or before work. And I have to mention here that there's always a risk in that people that are involved in relationships, whether they're married or not, even though they're consensual, can create an issue in the workplace if things go bad, if they break up, if there is acrimony between the two of them. That can add to a hostile work environment, harassment environment in the workplace, because people don't want to have to deal with that. And I need to mention also, even though many states have prohibitions against anti-nepotism rules, meaning two people cannot be working in the same place if they have any form of relationship. It should be a part of a policy that if two people in the workplace have a relationship, if they're married, if they're dating, whatever the case may be, if there's a close relationship, never should one of those people be supervising the other. That should never happen. And if that happens, then the employer should take steps to move those people apart. Automatically move the woman? No, because that would be discriminating. You look at what is reasonable to do. And I was involved in a situation many years ago when that happened. There was a manager that was having a relationship with a subordinate. And it was a large retail chain. They asked me, I said, it can't happen. So they transferred the manager. They thought a lot of that woman who was a subordinate, we don't want to move her from that department. She does a great job. We can move the manager to another department. And that's what they did. Okay, now here's one that I think a lot of people don't think about. And I actually raised this because when I was working for a law firm and preparing training, this question was asked of me. Don and Bill go to a conference. After the conference each day, Don asks Bill if he wants to go to dinner and discuss the conference topics. Don and Jane then go to a conference. After the conference ends each day, Don goes to dinner alone without asking Jane if she'd like to go to dinner. And he does that because I just don't feel comfortable going to dinner alone with a female colleague, even to discuss conference topics. That's Don's attitude. Is that okay? You know, I'm really sorry Don feels that way, but that's not Jane's fault. That's his fault. And he needs to get over that, because why should Jane be discriminated against and not be able to sit down and talk to Don over dinner about conference topics when a male colleague was able to do that? So that is clearly a form of sex discrimination, and it could constitute a form of harassment. It's making the workplace very uncomfortable, and it is putting her at a disadvantage because of her gender.
So we've received two questions that we will answer. Either we're going to answer it through these slides or we'll answer them at the end. One is about drafting a policy and one is about counseling someone how not to use foul language in the workplace. So one more example, we have Lee, a new physician in the practice, stops outside of the managing physician, Pat's office, to ask a question. Pat puts an arm around Lee and says, "Here, let me answer your question," and leads Lee into Pat's office. So as we said before, this type of touching behavior can be definitely considered offensive by the receiver and could also be perceived as a battery. So that can go two ways. That's the EEOC issue and also a criminal issue, which leads us to contractual requirements. And this is something that we want to share with you because we do a lot of drafting and reviewing of physician employment agreements. And now we're seeing very common language in contracts that require physicians to use what is being called professional behavior at all times in the workplace. We're also seeing explanations of that, which include not using foul language or getting along with people, the ability to get along with people in the workplace. That is a material term of the contract, and a physician can be terminated for cause if they're found violating those contractual terms. So we counsel our physicians who are becoming employed to note that that is a material term of the agreement. And what I say, especially to the young physicians, is when you're in the workplace, just do your job. You don't touch people. You don't make disparaging remarks about anyone or your employer. And it would be a good idea if you are the employer, if you have a practice and you have employment agreements with your physicians, it's a good idea to include that language as well. And in your contracts for your employees, you can refer back to policies, including harassment policies or your compliance policies, that those employees are going to have to follow.
Thanks, Mindy. So, okay, we have a situation in which a person believes he or she is in a hostile work environment, has been the victim or has witnessed hostile work environment harassment. So what does that person do? Well, there's no law and there would be no policy and there would be no reason for the harassment, the person who's been harassed, to say something to the person who is engaged in the conduct. Tell that person to stop. If someone tells a dirty joke and it's offensive, there's nothing wrong with saying, "That was really offensive. I didn't appreciate it. I would appreciate it if you never do that again." If the person says, "Okay, I'm sorry. You're right. I shouldn't have done that. I won't do that again." The issue's stopped. The harassment hopefully has stopped. If it hasn't stopped, then we have another issue because now maybe it was severe, maybe it wasn't, but it becomes pervasive. There may be situations in which the person that's the victim of that does not want to confront the person. And that can be in situations in which there's been an offensive physical touching. If somebody is so bold to touch somebody offensively, that person's probably not going to take it well when you say, "Stop doing that." If it is some racial remark, something based upon someone's national origin, people emboldened to do those kinds of things, unfortunately, aren't going to be rational. And in those cases, it may not be a good idea to confront that person. But if you feel comfortable doing it, if you feel safe in doing it, that's fine. However, it shouldn't stop there. You should always report the conduct to human resources if there's a human resource department, to practice management if there's a practice manager, to anyone in the organization that has been assigned the duty of investigating, receiving and investigating harassment complaints. I want to mention something too, that if somebody says something so clearly offensive, and you find this too, somebody says something that is, as I said, clearly offensive. It may be something racial. It may be something based on national origin. It may be something that is just kind of so offensive from a sexual standpoint. The person says it and says, "I'm sorry, I didn't mean that. Bad joke, please. Forgive me. I take that back." you can't take it back. As they say, you can't put toothpaste back in the tube. It's out. And if a person is a victim of that directly or has witnessed that, it should still also be reported to whomever is in charge of receiving complaints and doing investigations when it comes to harassment. Also common in the workplace is somebody that has been the victim of harassment, has witnessed harassing behavior, goes to somebody in management, a direct supervisor perhaps, and says, you know, I want to tell you something that just happened. I don't want you to do anything about it. So it's kind of off the record, okay, but so-and-so just did this. Here's the problem. That supervisor, that manager, that person with authority that represents the organization, that under the law is the organization, has to say, thank you for telling me that. I do have to bring this to the attention of HR, practice management, whoever is in charge of receiving and investigating complaints. Why? Because when it comes to hostile work environment sexual harassment, in order to hold the employer liable, the victim is going to have to show that the employer had knowledge of it. And as soon as that victim tells somebody with management authority that this occurred, employer now has knowledge of it. And even though that person may have said, don't report this, if later on harassment becomes an issue before the Equal Employment Opportunity Commission, the first thing they're going to ask is, did the employer have knowledge of this? And the first thing the person filing the charge, the victim, is going to say, yeah, I told the supervisor this. And the fact that he or she may have told the supervisor this is off the record doesn't count. That's not a defense.
And if I could just add there, this is a good reason to have harassment training for your staff, because this situation that Tony just mentioned happens all the time. Because human nature is, there's something happens in the workplace, there's harassing behavior going on, the employee just wants to vent and go to someone and say, get it off their chest. But that does constitute notice to the employer. And when people are unhappy and they file a claim or they want to go further legally, they will say that they put the employer on notice. So it's very important to educate your staff that they can't have anything off the record. If a complaint like that comes to them, they're going to have to bring it to you. Okay, sorry.
No, thanks, Mindy. And I also want to reiterate that if the person that is engaged in the harassment is a supervisor, is a manager, the employer is on notice. So there's no, the Human Resource Department in defending one of this charges based on harassment can't say we didn't know anything about it, because if it was a supervisor, somebody with a management authority, the law says, yeah, you did know something about it because the person that did it was actually the company. It was a manager. So what happens when somebody then comes to HR, comes to practice management, whatever entity, whatever committee, whatever department an employer is to receive these complaints and investigate it? Under the law and under a policy, that department, human resources, whomever it is, has a duty to investigate it. An investigation should be thorough. They should be far-reaching. That means that they should be speaking to the victim. They should be speaking to the alleged harasser. They should be asking about any witnesses that may have seen this, because they're going to have to make a determination as to whether this occurred. And it's vitally important that these investigations, these internal investigations, be done confidentially. And that means it doesn't become shop talk, as they say. It doesn't mean that they report to everybody involved in this what's going on. It is between human resources or whatever department is investigating this and the victim and the alleged harasser and the witnesses, and they don't share information. Even to the extent, let's say that an investigation occurs, and as a result of the investigation, they find that this did in fact occur, and they take action against the person that did the harassing. The point of all this is to make harassment stop. That's ultimately the goal. So if the victim now comes and says, I want to know what happened to John or Mary, that was the person that engaged in harassment, the answer is, we've taken care of it. Have you been harassed again? and if the answer is no, then we're done. Because their duty is to stop the harassment, not to tell the victim, yeah, we fired that person, or we demoted him or her, or we transferred him or her. We took care of it. We've taken the proper action. There is only one instance in which I have disclosed to a victim, and that was through the victim's attorney, what the ultimate remedy was. And I'll give you this example. Two people sitting there eating lunch at a picnic table outside the workplace, and one of them, a male, gropes the female. She immediately reports that to HR of the organization, and then shortly thereafter calls her attorney, who then gets involved. The company does a thorough investigation. There were no witnesses, but they were able to determine, yes, this occurred. As soon as she made that complaint, they suspended that employee that had been accused of a conduct without pay. And as a result of the investigation, his employment was terminated. Right when the investigation concluded, I got a call from the victim's attorney saying, well, we want to talk about a settlement. They wanted money. And I said, you're not getting any money. Why not? Because the company took action. What did they do? They fired him. Oh, end of conversation. It was reported, they investigated it, they took action, the harassment stopped. And that's what their legal duty was. And they owed that victim nothing. They weren't aware that this had occurred until she made the complaint, and they did what they were supposed to do. So the outcome, except for those extreme cases in which there's generally counsel involved, is not going to be anybody's business but the company's.
So I want to just add here that if this happens to you in your practice, it may be your first time that this occurs, and you might wonder, what do I do? So Tony's talking about the investigations of these claims, but what do you really practically do? Because you're looking at a potentially compensable event. So we recommend that if you're going to do an internal investigation using your own staff, not everybody's got an HR department. I mean, there may be one person who's in charge of this. We recommend that one person be the receptor of the information. That one person gathers everything. Because human nature is like the telephone game where, you know, the story keeps changing. So one person should be gathering the information. And I'm not going to go into all the legal implications here, but it's a good idea to consult with legal counsel before you start an investigation to make sure that you can protect the information that you gather. And there are ways to do that, but you will need someone to advise you on that. So right now, just remember that if you do an investigation internally, you want to have one person be the coordinator of that. And I would suggest that you just call your attorney to get outside counsel on the fact that you're doing it. Okay, go ahead.
Thanks, Mindy. Okay, so what are the possible outcomes here? You'll see on your screen substantiated claims. That means that someone has complained about potential harassment in the workplace, a proper investigation, confidential investigation has been done, and the person investigating, the department, whomever, has determined this happened. It was a violation of policy, violation of law. They're obligated then to take steps to make sure the harassment stops. Again, it should be confidential, and take whatever disciplinary action may be appropriate against the person that engaged in the conduct. We also have something called an unsubstantiated claim or unsubstantiated complaint. And that's when after an investigation, it's determined we don't know whether it happened or not. Or it may be something that turned out to be a misunderstanding. It may be something that somebody didn't hear right. It may be something that an overly sensitive employee took in the wrong way, like, you look very nice today. In those types of cases, that will be considered unsubstantiated, but will not lead to discipline or any form of adverse employment action against either the person that was the victim or the person that was the alleged harasser. What may occur in that case is just a conversation with each, saying, this is what the policy says, and this is what we expect. Please just adhere to this and be compliant. And that will be the end of it. And nobody will have a record of violating the policy. We also have something called a false claim. And that relates to that example I gave you, in which one person called another and said, I'm going to get you for filing that false claim. A false claim is when somebody makes a complaint and says something happened that didn't happen. And the person was making that complaint in bad faith. More often than not, that occurs when somebody has had a relationship that has gone south and they want to get back at the other party. That is a violation of the policy. It's a violation of the law, because making a false claim about somebody, claiming that they have engaged in harassment, is in and of itself harassment. And although the person that's the alleged harasser, who is now subjected to that false claim, should not be doing anything, the company would be in a position to discipline that alleged victim for filing that false complaint.
Just to let you know, 5 minutes remaining.
Okay, I will move it along. So consequences, discharge up to, or discipline up to and including discharge. What does a victim do? First of all, have to file a complaint with the employer. The employer has to be on notice. Can file a charge with the Equal Employment Opportunity Commission or the appropriate state agency. Under federal and state law, you can't just file a lawsuit in court. You have to go to the appropriate government agency with your claim first.
We're going to skip to slide 47.
Okay?
Okay, we had a couple questions, so I just want to summarize here. If you are contacted by the EEOC or the appropriate state agency, you want to read the information carefully. This goes back to the investigation. You're going to calendar the dates that responses are due, comply with the request, take the charge seriously, assign your defense to a qualified person, which in my view, that would be an attorney. And then don't forget that when this comes through the door, you want to think about reporting this to your relevant insurance carrier, which is usually your D&O, directors and officers, or it could be your employment liability carrier. If you are a business, you probably have that coverage, so you would check with your broker to see if you need to report that, because you don't want to have a problem later with the insurance carrier saying that you did not put them on proper notice. And finally, as our prior speakers mentioned, a good compliance program already existing is a great thing to have, because if any agency comes in and looks at your practice and you show that you are trying to act in good faith, they're going to give you credit for that. We did have some questions that popped up on the screen. Would you like us to answer those, or would you like to repeat them, or how do you want to handle it?
Sure. There are a number of questions that have come up. So let's address as many as we can. But thank you for a very well coordinated presentation. One of the questions that has come up is in New York during this COVID era, there were residents protesting outside hospital for lack of PPE, and they were told that they would be fired if they don't stop that behavior. And many of the residents were Indians. The question is, does this constitute harassment? And also, because they are Indian, based on the race, how would this be handled?
Would you like me to handle that? Well, in and of itself, it wouldn't necessarily be considered harassment based upon national origin if, in fact, they were treating people of other national origins, other races, equally. I don't think that the fact that they're being threatened with termination would constitute harassment. However, if only the Indian physicians were being singled out, then yes, that would be harassment. However, if it were Indian physicians, American physicians, Asian physicians, and it was being done without regard to national origin, it would not likely constitute harassment under the Civil Rights Act.
But it could be an OSHA complaint.
It could also be an Americans with Disabilities Act complaint if any of those people were complaining because they were at risk because of disabilities.
Thank you. The second question is, how would it be handled if a subordinate asks supervisor for the favors in return for sexual whatever?
That would be hostile work environment sexual harassment. It couldn't be quid pro quo because that subordinate would have no authority to give anything to the supervisor. But just because you're a supervisor doesn't mean that you cannot be harassed. And therefore, that could be considered hostile work environment harassment.
Thank you. Next one is the F-bomb being a commonplace in the workplace. If it continues, would that be considered a harassment?
It could be. If it was done once or maybe twice, probably wouldn't. I mean, let's face it, who doesn't swear sometimes? So you would have to look to see if a reasonable person would have been offended by it. If it happens constantly, and it very well could be considered harassment, very well could be considered sexual harassment because it creates a hostile work environment. Offensive language is certainly a form of hostile work environment sexual harassment. So if it occurs a lot, if it becomes something that's just done every day, it would not be unreasonable for a victim to say, I don't like this, I don't want this to happen. Because, we are all stressed. Sometimes we say things we don't mean. I've been representing physicians in hospitals for 30 years. It's a very stressful environment. But if it just becomes then a matter of the workplace every day, it's something that needs to be considered.
But let me add to that. If you don't document what you do, the rule is still out there. The thinking is still true. If you don't document something, it wasn't done. So in this example, you have somebody who's using the F-bomb. You might think to yourself, well, what's the big deal? I told him or her to stop it. Okay, but you need to document that you told him to stop it and put that someplace so if it spins out of control later and somebody does file a claim, you can show that you tried to address it.
Thank you. Next question, the dating policies and regulations in workplace, are these different in different states?
They are. Illinois, for instance, as I've mentioned, anti-nepotism rules are illegal. And it depends on state law in that case, yes.
Next question, is there a time limit to file a complaint?
Yes, there is. Well, first of all, there wouldn't necessarily be a time limit to file a complaint with the employer. That would be up to the policy, but policies, I've never seen a policy that puts a time limit on it because that would be something that would inhibit someone potentially to filing a complaint. But once that person decides, I need to go to the Equal Employment Opportunity Commission, and I need to go to the Illinois Department of Human Rights and file a charge, those being the appropriate state agencies, you have 360 days to do that.
Thank you very much. There are at least 3 or 4 other questions that I don't think we have time to go through, but I want to thank you very much for the presentation and examples of various behaviors which are very easy to understand rather than a legal language. So thanks very much.
You should feel free to email us with questions. Thank you.
Thank you very much.
Thank
Hi,
you.
Dr. Nadkarni.
The next session is a clinical one on neonatal and pediatric resuscitation. And we have a team of stalwarts, Dr. Vidyasagar and Dr. Vinay Nadkarni. And both of them are original investigators in the field of resuscitation. They are researchers, they have published a lot. They have done a lot of international collaboration. Dr. Vidyasagar is now a professor emeritus at the University of Illinois in Chicago. And Dr. Nadkarni is a professor of anesthesiology, critical care, pediatrics at the University of Pennsylvania Perelman School of Medicine, Philadelphia, Pennsylvania. The platform is yours.
Thank you, Dr. Rohit. May I have the control, please? Yeah. Birth asphyxia is a major problem in the world. Is it working? No. Okay. Globally, asphyxia is a very big problem. Of the 125 babies born every year, 4 million die during the neonatal period, that is, during the first 4 weeks, right? 1/4 of them, the million babies, die due to birth asphyxia. Hence, it's a very critical for us to get prepared for the baby's well-being. Why are the babies at risk of developing birth asphyxia? For those who do not deal with in OB or neonatology, but as birth of the baby initiates the first breath leading to transition from in utero placental dependent physiology to extrauterine neonatal physiology. Commonly, the first breath is recognized by the big cry the baby gives in the first seconds. The transition may be affected by several factors, such as maternal, placental, and neonatal causes. And we have to recognize them to be prepared to address those problems. Failure of this smooth transition leads to birth asphyxia. Luckily, 90% of the babies born have a smooth transition. About 10% of them require some assistance at birth. 1% of all births require extensive resuscitation. To avoid birth asphyxia and resultant morbidity and mortality, there is a need for a presence of skilled healthcare personnel at birth to provide resuscitation at all births. So remember, to avoid birth asphyxia, we need a skilled person available at the time of birth. Now, to ensure the skills of the birth attendants, neonatal resuscitation training programs have been developed. There are two major educational programs. One is the neonatal resuscitation program, NRP, and the other, Helping Babies Breathe, both developed by American Academy of Pediatrics in collaboration with American Heart Association and International Liaison of Committee on Resuscitation. And these programs are very standardized. They are accepted globally as a practical tool to improve the neonatal survival and reduce deaths from birth asphyxia. Both are developed on evidence-based medicine and put major emphasis on building skills of personnel. And both programs have spread around the world and in training thousands of healthcare personnel. The neonatal resuscitation program, which was initiated in 1987, is suitable for training the in-hospital personnel and has been translated into 24 languages, implemented in 130 countries. I want to again emphasize, this is an in-hospital program, a program for in-hospital working workers. And it has been evaluated or updated every 5 years to be current with evidence. New evidence is developing. The last one was developed in 2015, which is a 7th edition. The Helping Babies Breathe, on the other hand, was developed in 2010, designed for low-resource countries, and it has been implemented in 80 countries, trained over 500,000 birth attendants around the world. There's a great emphasis in both programs in anticipatory preparation, because it's important for us to recognize the mothers at risk who may have a babies at risk at birth, and be prepared to have the presence of a skilled person, a team at the delivery. Every birth should be attended by at least one person trained to perform initial steps and provide positive pressure ventilation. And the responsibility of this person is only to address the issues of the baby and nothing else. The management algorithm developed by these programs are shown here. As you see at the top of the screen graph, preparation of the antenatal care and developing a team, reviewing the briefing and reviewing the equipment checklist is very important. Now, from birth up to 1 minute, this is called a very important critical period called the post-golden minute. We have to assess the baby quickly, whether baby is term and baby has a good tone, breathing or crying. If so, we can give the primary initial care of the baby and give it to mom. If not, then we have to assure that the baby is warm and maintain normal temperature and position the airway, clear the secretions, keep the baby dry and stimulate, and continue to watch. And if the baby continues to have apnea, gasping, then you should go for positive pressure ventilation. If not, and if the baby has a simply labored breathing and a persistent cyanosis, and then again position the neck and mouth and clear the airway and monitor the baby for oxygenation with a pulse oximeter and also heart rate so that we can continue. So please remember this birth to this 1 minute is a very critical. It's called a golden golden minute, because unless we establish, go through proper steps and maintain this baby airway and temperature, we'll have a much bad outcomes. So we continue to evaluate the baby. Decisions are made based on the respiratory effort, heart rate, and for measuring the heart rate, it is recommended that we have a ECG lead rather than depending on only an auscultation, because it may be inaccurate. And pulse oximetry is important to monitor oxygenation of the baby. Now, again, this expanded version of the first minute, same issue, same statement, term gestation, breathing or not, if the baby is doing well, go to given to mother. And if not, you continue to follow these babies. That's a heart rate. If the heart rate is below 100, then continue positive pressure, go to positive pressure ventilation. If it's not below 100 and only labored breathing, give oxygen and continue to follow the baby. And if there may be a proper place for application of CPAP if the baby continues to have respiratory difficulty. Now, most essential for newborn babies, and particularly the premature babies, is to maintain the body temperature in the delivery room during this resuscitative period. It's enough for the preterm babies to be wiped and keep it dry under the radiant warmer, but particularly premature babies, we need additional attention. In extremely small babies may be received into plastic wrap and put a cap to decrease the heat losses. Thermal mattress may be used, warm humidifier gases instead of cold gases, increase the room temperature to maintain the room temperature, and have a portable incubator ready. In a vigorous term baby, routine care can be given with no risk factors, and babies who require an initial steps can be given to mother for skin-to-skin contact, what you call kangaroo care, and clear the airway and continue to monitor the babies. Now, when should we give oxygen to the babies? If heart rate is greater than 100, but baby is labored breathing, term infants can be started not necessarily 100% oxygen. Actually, we avoid 100% oxygen, give the baby only room air with a bag breathing. But in preterm infants, particularly, we start with a low oxygen to up to 30%, and oxygen is titrated to achieve preductal oxygen saturation, which I will show you what levels we should be achieving every minute. Initiate the respiration of the resuscitation of the preterm infants with high oxygen. Not the really, as I mentioned, high oxygen is not indicated in this resuscitating these babies. If heart rate is greater than 100, but labored breathing, oxygen saturation cannot be maintained with the tolerated levels. Despite 100% oxygen, we should consider for CPAP or positive pressure breathing. Here are the oxygen saturations we should be achieving in the babies. Within 1 minute, saturation should be going to 65%, by 2 minutes, 70%, by 3 minutes, 75%, but at least 5 minutes, 85%, and 10 minutes, 95%. These are the normal saturation, the healthy newborn babies who are vigorous and active, they do not care. So we need to achieve the oxygen saturation levels accordingly. Problem, okay. Now, next is the application of chest compressions. Indications for chest compressions are if the baby's heart rate is less than 60 beats per minute in spite of 30 seconds of effective positive pressure ventilation. 100% oxygen continues to be recommended when administering chest compressions. Now, how do we apply the chest compressions? We use a two-thumb technique, which I'll show you. Okay. You see upper panel, two thumbs are placed here, not two fingers like this. This is an inappropriate method of chest compression. Whereas in the transfer, literally you can see, push the chest, your thumbs, and with the palm behind the baby's chest, and compress the chest to at least 1/3 of its diameter. While we are doing chest compression, babies can be resuscitated with a self-inflating bag, or in some delivery rooms, we have a TP resuscitator, which can be used to continue monitoring. While you are doing chest compression and oxygen, and if the babies are, you must continue to reassess the baby every 15 seconds using an acronym, what is called Mr. SOPA, what means if the baby is not responding well, you should look at the mask and adjustment properly, reposition the airway by adjusting the head in a properly, suction the air mouth, and open the mouth slightly to make sure that mask is properly applied, and pressure, increase the pressure, and consider airway alternatives such as endotracheal tube or laryngeal mask. Now here the appropriate position of the baby's neck and chest with a little support under the chest, but you should not be hyperextension or hyperflexion of the neck. If needed, endotracheal intubation is placed, and the appropriate tracheal tube and size can be measured from the nose to the ear, but also there are tables available to use according to birth weight and gestational age. Now, if the heart rate is not increasing and there's no chest movement, despite Mr. Sopa's corrections, as mentioned before, obstruction should be considered, and suction can be performed either using a catheter of the endotracheal tube or meconium aspirator. There are few medications, hardly really speaking, the major medication used in the babies who do not respond well is epinephrine. I should mention okay. If the heart rate remains below 60, after 30 seconds of effective positive pressure ventilation, or another 60 seconds of chest compression using 100%, that's when epinephrine is indicated. One dose may be given through endotracheal tube. If there's no response, additional doses can be administered through the intravenous dose via umbilical venous catheter or intraosseous technique. A concentration is 1 in 10,000, that is 0.1 milligram in 1 ml, and through endotracheal tube, we can use 0.5 to 1 milligram per kilo. Through umbilical venous catheter, a 1.1 to 0.3 milligram ml, follow with a flush to clear the tube, and continue repeating 3 to 5 if indicated. That is, if the heart rate does not come up in spite of positive pressure ventilation as well as administration of it. Only other medication may be necessary for the babies. Is babies who are hypovolemic. In these babies, normal saline or blood of 10 ml per kilo for treatment of severe hypovolemia. Make sure to address the sodium bicarbonate to correct acidosis, naloxone for respiratory repression is not indicated. So please recommend, is not recommended, unlike olden days, we used to give bicarbonate and naloxone, but you mainly depend on resuscitative efforts to the positive pressure ventilation and oxygen. Now, there are special scenarios that we should consider. The major issue is when to ligate the cord, umbilical cord. In a normal circumstances, the recommendation of the clamping of the cord is the first 30 to 60 seconds is reasonable for both term and preterm infants who do not require resuscitation. However, if the babies have suffered placental circulation is affected, such as after placental abruption, bleeding of the placenta, previa, bleeding vasa previa, all these issues, we do not wait for 30 to 60 and clamp the cord immediately and provide the resuscitation. Now, other issues, the circumstances in which the babies are born, meconium strained amniotic fluid. There's been a lot of debate and a lot of research in these areas. The major thing is routine intubation for tracheal suction is not suggested in a vigorous baby. But if the infant is born to meconium strained amniotic fluid is vigorous, initial steps of resuscitation should be completed on the radiant warmer. Positive pressure ventilation should be initiated if the infant is not breathing according to the protocol that we have seen before. Now, other conditions, if the baby is not responding, immediate things we need immediate attention is to recognize the pneumothorax, which can be treated with a percutaneous needle aspiration, or a presence of a pleural effusion. Percutaneous needle aspiration will be helpful. Usually, congenital diaphragmatic hernias in today's medicine, antenatally, many a times they have been diagnosed. So we are well prepared for these babies. These babies require very careful intubation and continuous management. But it's important for the people to understand these antenatal problems. That's why you have a antenatal preparation, anticipated preparation. Now, what do we do after resuscitation? If the babies are develop what is called hypoxemic ischemic encephalopathy, these babies can be treated with a therapeutic hypothermia, but particularly there are several criteria. A lot of work has been done in the babies who are greater than 36 weeks. If therapeutic hypothermia is initiated, it should be done within the first 6 hours of life, and they are done only in a specialized units where all the facilities are available and a trained personnel to manage that one. When to stop the resuscitation? This is a major issue. Again, antenatally, when we discuss with the mothers who are at risk, who are very preterm babies, preterm gestational age, less than 23 weeks gestation or estimated 400 grams of weight, are non-viable, or babies with a congenital anomalies, non-viable. In these cases, antenatal diagnosis, antenatal discussion with the parents developed, and we may decide not to resuscitate. However, if you face suddenly, you may assess this in the delivery room and if these are the two conditions under which resuscitation may not be indicated. However, in a term baby or a premature baby, continuation of the resuscitation up to 10 minutes with a zero upguard, meaning this baby does not have a respiratory effort, does not have a heartbeat at all, and these are the strong predictors of mortality and morbidity in the late preterm and term infants, and decision we may reasonably discontinue resuscitation in these babies. So if there are any other problems, actually anticipatory, a lot of discussions are made in collaboration with the obstetricians and mothers, and if necessary, some ethical decisions and ethical diagnosis to be made. Thank you.
Go ahead, Dr. Nadkarni.
Very good. Well, it really is a pleasure and an honor to follow Dr. Vidyasagar, who is the giant whose shoulders we stand on. And what I'd like to talk about for the next 15 minutes or so is what's happening beyond the delivery room in the neonatal intensive care unit and beyond. I have no important conflicts of interest, although I do have some research grants and sit on some scientific advisory boards related to resuscitation, but none of what I'm going to discuss today is intended to endorse any product or module. How do we bridge and go beyond the neonatal resuscitation program through PALS and essentially through the developmental stages to improve resuscitation around the world? What Dr. Sagar has just discussed with us is what we do in the delivery room as we emerge and go from birth and transition to the neonatal intensive care. And then beyond, what do we do in PALS? We all know that the emphasis on ventilation is extremely important during that transition period and in young infants and children. And thus the neonatal resuscitation program, NRP, emphasizes ventilation and deals with bradycardia evolving to asystole as their primary cardiac arrest, rhythm, and problem. PALS is a broader continuum as the disease processes get very diverse, including trauma, respiratory compromise, and congenital heart disease with associated bradyarrhythmias, tachyarrhythmias, and even ventricular fibrillation or pulseless ventricular tachycardia in 10% of the cardiac arrest victims. So how do we think or reflect on what Dr. Sagar has taught us over the years about the importance, and what can we do with very simple tools like our hands and CPAP or flow, and what requires advanced technology? As we think about this, we must think about the knowledge and the level of evidence behind what we do and translate that into what we can teach, learn, remember, and act well. And then start to concentrate not only on whether it can work, but whether it does work, and if it works, does it result in better neurologic survival and quality of life? Simple survival with poor quality of life is not the objective. Of course, we work in different circumstances. I work at Children's Hospital of Philadelphia. We have 40% of our beds in the hospital now. Our ICU beds, 100 neonatal, 100 pediatric. And with this configuration and enlarging tertiary and quaternary care centers, we recognize that many of our resuscitation teams are ad hoc. At CHOP, we have more than 1 million combinations of 5-person teams that could be called upon to resuscitate a child at any given day. So how is it that we can train them and prepare them to do the few essential things that need to be done during resuscitation and do them well? Of course, in the area of COVID, we should be thinking of how the training of our practitioners could be more like immunization, the concept of herd immunity. How many people do we need to train in order to protect the community of children during cardiac arrest? And we also have to think about the immunization, or how that learning drops off. How do we forget? And how often do we need to train to remember and to achieve excellent performance? So what are the key lessons that we have learned and are still learning over time? We know that one size does not fit all for physiology or anatomy. We know that high quality skills and behaviors are needed, and these are best supported by low doses and high frequency of training. Also, training just in time at the teachable moment when we anticipate a child is in a high-risk condition. Capturing what we do, auditing what we do, and feeding it back so that we can coach our performance, and forming collaboratories where we can collect this information, create dashboards, and reflect upon it. It is not just about the process of care, but more about patient outcome. We must learn how these patients are doing in the long term. And we must recognize that it's not all about fancy gadgets and technology, but much about human factors and communication, where audit and debriefing is the key. If we think about the neonate and how the airway and the newly born is totally dependent on effective ventilation to prevent and treat evolving cardiac arrest, and in the older patient, how trauma and dysrhythmia and coronary issues really emerge, we can see that the tools that we need to emphasize are different in the very young child compared to the older children, adolescents, and adults. In fact, even in children, the many, many different types of diseases that we have to deal with are now packaged into single algorithms, PALs, which tend to put us in a one-size-fits-all approach, but this may not fit the individual patient. The principles of prediction, detection, assessment, teamwork, communication, monitoring, feedback, quality, these are all the same for all children and adults. But the specific methodology that we achieve the right treatment at the right time is what we are striving for. By teaching individuals, low dose and high frequency, teams, and providing performance feedback and performance debriefing, we can achieve these goals. Just like medications or antibiotics, a low dose, high frequency kind of escalating training may be one of the ways forward. And in fact, in Dr. Sagar's field in Tanzania, frequent brief on-site simulation training of frontline providers reduced the 24-hour neonatal mortality significantly, and even in resource-limited settings. But think with me for a moment how we currently train and make guidelines. We give guidelines for rescuers, how deep, how fast, how long interruptions can be, what dose of shock we set on the machine. These are things that are rescuer-centric. But indeed, perhaps we should be moving much more towards what the patient needs, which is much more of a physiology-based approach. How can we use the things that are happening on the patient to guide us, like diastolic blood pressure, end-tidal CO2, coronary perfusion pressure, tools like near-infrared spectroscopy, or echocardiograms, or current density rather than shock dose in joules. In fact, the American Heart Association has guided us that when available, monitoring patients' physiologic response to either blood pressure or end-tidal CO2 is superior to our anatomic-based guidelines. When we measured in our hospital in 2009 our performance for rate, depth, and leaning force, we found that more than a third of the time we were not meeting the American Heart Association quality targets, even in our center that was very focused on delivering good quality care. And when we did this across a network of 40 different children's hospitals, we again found that particularly in the young children, we were not meeting our metrics for chest compression fraction, rate, and depth. But we did see, when we measured, that the deeper we pushed, the better the blood pressures that we generated during CPR. And when we met the American Heart Association targets for depth, our return of spontaneous circulation and 24-hour survival were significantly better. And when we measured and fed back to the providers their performance and debriefed on it, we could improve the amount of excellent CPR delivered in the dark bars. And we could also improve the discharge and neurologic survival of the patients just by adding that audit and debriefing program. In fact, the American Heart Association has now incorporated this low-dose, high-frequency training and performance feedback into their resuscitation quality improvement programs that exist for children and adults and are being developed for the neonatal resuscitation program. Adding a CPR coach like Adam Cheng in Canada has done in the black bars has increased excellent CPR for depth, rate, and chest compression fraction. And this multi-center randomized simulation-based trial was very important to show that we should perhaps put a coach in the resuscitation team. Betsy Hunt and the folks at Johns Hopkins Hospital are now studying this in the rescue network. But if we think about these variable disease processes and our one single-sized approach, it's not really like precision-based medicine. And it doesn't really make physiologic sense that across the age and physiologic spectrum, all patients should get the same treatment. So the American Heart Association suggests that we should monitor the physiologic response when possible and titrate our resuscitation evidence to physiology. In fact, in observational studies across our research networks, we're able to show an association of better diastolic blood pressures with better survival outcomes. And we can create advanced tools to train to blood pressure rather than depth. End-tidal CO2 has been used and demonstrated by Hamrick to improve the mean arterial pressure and cerebral perfusion pressures when we use end-tidal CO2 to guide CPR, at least in the pig lab and in older patients. And look at this. I'm going to show you two echocardiograms that were obtained during CPR through transesophageal echocardiography. Here is the left ventricular outflow tract, and you can see in the video how the outflow tract is being compressed during CPR by the hands in the standard position. But when we do a minor modification of the hand position during CPR, now you can see that in the same patient, the outflow tract is now open and not being compressed. And so the blood flow is better. These types of advanced modifications are almost available and coming down the pike. So what do we know? High quality CPR is not common. Better CPR leads to better outcome. Point of care, POC training, improves CPR quality, and audit and debriefing combined with this point of care training can improve survival. There are indeed some goal-directed physiology-based responses that we can monitor and feedback now with new tools being developed. But can we train the team and the environment to achieve this high quality physiology, goal-directed CPR that will save more lives? We have ongoing studies right now that are using the existing tools to in fact bring this to the fore. Using stepped wedge design, a 4-year study is being completed that will be published in the next year and a half. We can screen through our electronic medical record those patients in our hospitals and ICUs that are most at risk. We can prepare them with on-the-spot, just-in-time training, and we can develop protocols that identify pre-arrest, train providers pre-arrest, provide feedback during the arrest, and then do small, frequent, low-dose training for the post-resuscitative care that should result in improved survival and better neurologic outcomes. We can now capture in the Viper network live actual resuscitations and measure what we're doing. In fact, Aaron Donahue at CHOP has done this with collaborators, and they've actually examined and documented the compression rate delivered in real resuscitations, how few of them are between the recommended rate. And here's the ventilation rate, where a much higher ventilation rate is provided in real patients that we can see and monitor. When we look at the report cards from the monitor and the video and the defibrillator, we can generate report cards that can feed back performance to providers just after the fact. We can capture through eye tracking software. Through eye tracking software, we can look at what the providers are seeing. And here you can see a trauma team in our trauma bay where they are wearing headbands that are tracking near-infrared, functional near-infrared blood flow. So we can see that as their task is increased, where the blood flow is going and when they are becoming task flow overloaded. These tools are potential to help us study and learn how we can create better guidelines. This science is emerging, and the tools that exist for children and adults can be adapted to different size so that it is not man versus machine, but man and machine.
Just to let you know, there are 3 or 4 minutes left.
Yeah, and last slide. And we are developing networks that will allow us to study and learn more about this. So what have we learned? One size does not fit all. Audit and debriefing is the key. And learning and training with low dose and high frequency makes a difference. Thank you.
Thank you very much. Great team presentation and a great review of science and global health and the NRP program. More than the questions, there have been several comments that have come up on the chat, and they've mainly addressed appreciation about Dr. Vidyasagar being back on the screen, and many people are happy to see him and talk about the NRP. There was one question you mentioned about NRP and PALS transition. And most people grapple with this issue if there is a specific age where this transition from one to the other should take place.
Well, obviously, neonatal physiology and birth asphyxia are so somewhat so different than a resuscitation in the older child or even a teenage, even a 1 month or 2 month baby. So I think the people who want to, who are providing the neonatal resuscitation have to be very much conversant with the fetal physiology, maternal physiology, pregnancy, and prepare themselves to understand what are the underlying physiologic changes. Because you see, unlike a growing child, fetus is totally dependent on fetal circulation and oxygenation. And at birth, baby has to adapt to external environment. It depends on the first maternal condition, maternal medication, but in addition, developmental problem, which the newborn babies are at various stages of development of the lung. Premature babies have surfactant deficiency, and older babies have other problems such as meconium aspiration, other things. So I think the transition from the newborn to pediatric age is really depending on the physiologic changes. They are quite different backgrounds in physiology.
Thank you. Thank you. Dr. Nadkarni, do you have anything to add?
I agree completely, especially on the physiology basis. Practically, I will say even in our hospital, we have the same debate because we have children in our neonatal intensive care unit with unusual diseases that sometimes are there for 6 months, 7 months, 8 months. A lot of what we do, whether it's NRP or PALS, it has the same objective. It's the training of the providers that might dictate whether we use NRP or PALS, whether we use 3-to-1 ventilation to compression ratio or whether we use 15-to-2. And also the physiology of the patient. If it's a primary respiratory problem, we must emphasize, like NRP, the breathing. But if it's a primary cardiac problem, then we emphasize the chest compressions and the higher ratio of compressions to ventilation. The NRP does have a statement in their instructor newsletter that summarizes when to transition based on training and physiology.
Thank you very much. And just to point out, the next NRP edition comes out next year, so things will change. But thanks very much, Dr. Vidyasagar and Dr. Nadkarni, for a great presentation. Let's move on to the next session. And the topic for next session is overview of global pandemics with a focus on COVID-19. And the speaker for this session is Dr. Ravi Durvasula, who is chairman of the Department of Medicine at the John W. Clark Endowed Professor of Medicine. He's a professor of public health sciences as well at the Loyola University Stritch School of Medicine in Maywood, Illinois. Dr. Ravi Durvasula, please.
Thank you. Now, let me see. Can everyone hear me okay?
Yes.
Good. Now, I am going to share my screen. I did send my slides in, but I think it's easier if I share off of what I have. Let me see. 1 second. Do this here. Okay. All right. All right. Now, is that showing up? Is my screen sharing on there?
Should I share the screen?
I hit share screen on my computer. I just want to make sure you can all see it, the slides.
Not yet.
Not there? Or let me try it again. Hold on. Now, I also sent you the talk. I don't know if you want to load it from there, but I should be able to just share it right off of my...
I can load
Here, it's okay. Here, I got it. I got it. I think I may have fixed the problem here. Now, here we go. Now, can you see it?
Yes.
Okay, I'm going to just hit from start. Here we go. Now it should say, do you see the screen that says Emerging Diseases, A Tale of Three Pandemics?
Yes.
Good. Okay, so let me begin. And I want to start off, thank the organizers of this meeting for the invitation. Certainly Dr. Bansal, with whom I've worked last few years at Loyola, and he got me hooked up to do this. And the topic today, my background is in infectious diseases, and I work a lot in global health and emerging diseases. And I think certainly talking about pandemics today, and this time is probably one of the most timely things. And I was asked initially to speak primarily on COVID-19, and I was thinking, you know, you can get the best information on COVID-19 from Wolf Blitzer or, you know, John King. They're just constantly talking about it. So I'm going to touch upon it, but I thought it would be a good time to step back and look at the perspective of where we are now with other recent pandemics and try to look thematically at what are the things that lead to emergence of disease, and really to ask a very blunt question: have we learned anything from what's happened in the last few decades? And so that's why I've titled this Emerging Diseases, A Tale of Three Pandemics. And I'm actually going to touch a little bit on three important and really ongoing processes: the HIV/AIDS pandemic, Ebola in West Africa, and certainly COVID-19. I want to start off by talking about HIV/AIDS as the first of these three pandemics. And what you'll see, especially in the first two slides, at the bottom in smaller print in red, just some of the themes. And we're going to come back to all of these at the end so I can provide an overview. But I'm going to use this term frequently. It's called a zoonosis. So HIV/AIDS is a zoonotic pandemic. And what that simply means is that it is an infection, it's a disease that has its origins in animals, animal reservoirs. And what you can see in this slide with a variety of the monkeys, the chimpanzees, etc., which are found in different parts of Africa, that this is an infection that has its origin in a group of what are called simian viruses, the simian immunodeficiency viruses, analogous to the human immunodeficiency virus, or HIV, and present in several of the different monkey species. And the ones that we've heard a lot about in the past, and some beautiful sequencing work and genomics that's been done on this, include the Sudi mangabe, from which HIV-2 evolved and moved into humans, and then certainly from both chimpanzee and the Western gorilla, where the simian variants evolved into a human type 1 virus that moved into the human population. Where it comes from, and this is an important theme you're going to see over and over in these kinds of diseases, is that the commercial activity, human commercial activity, trafficking of these monkeys. Some people call it bushmeat, that may be a little pejorative, but the concept of harboring, tracking, trapping, and marketing, somewhere along this line, whether it's through contact, scratching, bites, we're not entirely sure, the viral populations from the monkeys have moved into humans. And this, looking at some of the sequence data and genomics, might have happened as far back as 50 years ago. But the first cases of the human immunodeficiency virus, there's a cluster in San Francisco in 1983. Around the same time, there was some being reported in France, and that's when the virus was actually identified and things have taken off. So you can see a span in there of about a few decades before it started to show up in human populations. And if you go back, and here's another very important theme in emerging diseases, if we look at the early spread of these diseases, and here's a map you can see of West Africa, predominantly the DRC, the Democratic Republic of Congo. And if you look at the pathways of the spread of this virus, you can see here in sort of the colored lines, these follow commercial pathways, waterways, the rivers, railways, highways, and the migration of these cases. Now, I could take the same map and superimpose, and there are maps of Gujarat during the early days of HIV/AIDS, other maps in other parts of the world, where it's been very clearly associated that human activity, and largely in India, it was largely through trucking, and the association of commercial sex workers along these trucking routes that led to the spread. And then, as we know with the HIV/AIDS epidemic, after it became established in certain populations because of blood and bodily fluid transmission, so the gay male populations of the West Coast, injection drug users in the United States, largely on the Northeast side, and other parts of the world, there were some very unfortunate cases of outbreaks associated with transfusions before universal screening. So as these human behaviors progressed, the virus became entrenched and the disease progressed. So again, you see in the little red notations at the bottom, pay attention to commerce, human migration, and behavior. We're going to talk more about that. And over the course of about 20 years, and here's a kind of time series map of Africa, this became, from early days in West Africa, a true continental pandemic. And remember, when we use the word pandemic, I should just explain it quickly. We're talking about a condition in which there are multiple regional epidemics. So this could be across a region of a continent. It could be globally, as we're going to see with some of these things. But it evolved very quickly over 20 years, and something very important happened. And something which I believe, if you look at our current situation with COVID-19, we have not learned from this. Around the end of the 1990s, early 2000s, there was an active policy of denial of HIV/AIDS, that this virus caused this disease. The government of Thabo Mbeki in South Africa actually had an official policy of denial. In 2002, I was in Durban for the World AIDS Conference, and there's a lot of, this was being revealed that this policy was a disastrous approach to public health. And it's believed that close to 300,000 people died in that country because of this policy. And the politicization of this virus and the diseases that it caused, I think were important factors in what happened. This, by the way, there was a lot of denial in the United States and many other countries. So something that's important when we think about pandemics, and again, think about our current climate with our current pandemic. The impact in Africa was absolutely devastating. Not since the days of the Black Death. And we have to go back several centuries to be talking about the Black Death. Not since those days have nations experienced a drop in life expectancy. Human life expectancy in countries has increased steadily. And during this period, countries such as Namibia, South Africa, Zambia, and largely in the southern part of the continent of Africa, experienced a drop in national life expectancy, which was a staggering public health figure for people to understand. The other thing that made this epidemic or pandemic so bad was the confluence of both HIV and malaria in many of these sub-Saharan African nations, which I'm just highlighting here with the mouse. And so a twin hit on economies, almost a 2 to 4% tax per year on GDPs. But again, the themes to think about here, not only the spread, but the role of politics, stigma, and the fact that socioeconomically, this pandemic wreaks such havoc. By 2005, and that's when this map shows what was happening. This was the true global pandemic. 60 million cases around the world. Keep in mind, COVID-19 is now approaching 10 million. So this was a dramatic and huge pandemic and a zoonotic disease that really became established. Now, 1983, the first cases in the United States, no vaccine at this point. People have certainly been working on it, but keep that in mind as we think about going forward with other diseases. The good news, the light that was at the end of the tunnel, was about 12 years after the initial discovery of the virus, so around the mid-1990s, drugs became available. And the protease inhibitors, starting with sequinavir and many, many more, came through. And there's been a tremendous drug discovery process. And now people with HIV can live a normal, full life with as few as 1 to 2 pills a day. So I would say, you know, many lessons to be learned from this pandemic, but a good outcome so far, assuming that, of course, there's access to these kinds of drugs around the world. I want to now turn my attention to the second of the modern pandemics, and one that is actually still going on, just like HIV/AIDS. And this is, and many of you can recognize from the screen, this is an Ebola virus. And this is another viral disease. It's in a family of what are called the Filoviridae, which gets its name from philo means rope. So these are kind of like rope-like viruses, 6 altogether, 5 of which are human pathogens, and mostly Ebola, but there's also one called Marburg. And this is one that has not only wreaked havoc, especially in West Africa, but it's also captured the fancy of, you know, book writers and movie makers. It's a spectacular disease in the sense that fulminant hemorrhagic disease, terrible progression, and case fatality rates of close to 90%, which is really about as high as you can get, especially in a short period of time. HIV/AIDS without treatment has a mortality of close to 100%. Okay, untreated AIDS, people will die, but that may take 10 to 15, up to 20 years. This can happen in the matter of days to weeks, and so it's a truly a horrific disease. And again, when we go back to some of the themes here, this is a disease that also has zoonotic origins. And these days we're hearing a lot about bats, because we're going to talk about that with COVID-19, but this is another zoonosis coming out of animals that has its reservoirs in fruit bats. And many fruit bats, in especially West Africa, serve as the primary reservoirs of Ebola. But then, as you can see in this graphic, there are these secondary vertebrate reservoirs, and once again, gorillas, chimpanzees play an important role. So it is that, you know, progression from animal reservoirs through vertebrates, and then the commercial activity of humans capturing, marketing, eating, etc., interacting with these animals that leads to the transfer, that led to the transfer, I should say. And these are epidemics that have been going on for about 4 years, about 4 decades, I should say, but probably longer, but at least 4 decades that we know about. And you can see here some of the summaries. Almost all the epidemics of Ebola have occurred in West Africa, with the exception of one which occurred in Uganda in 2007. The current epidemic is actually still ongoing in Congo, and I'll mention that in just a second. No treatment. So unlike the HIV/AIDS pandemic, where treatments occurred, the treatments were discovered and moved forward, but no vaccine was found yet, the opposite's going on here. There are now 2 vaccines that are available that are actually being deployed now in Congo on compassionate use basis, and hopefully we'll be able to curtail, you know, future episodes. And as I've said, you know, it's a rapidly fatal disease. Unfortunately, this graphic that I'm showing here is one that's, the other day on TV, they were talking about Ebola, and this picture showed up, and it's awful when you see a disease associated with burials. And but that's how progressive it's been. And the most recent 2 epidemics have been by far the worst, with over 2,500 to 3,000 lives. Not all is bleak. Nigeria was threatened by Ebola in the recent pandemic, and spectacular public health responses in Nigeria led to control and actually very few deaths, as it was encroaching potentially on the city of Lagos, which is a gigantic metropolitan area. So there has been some very good response, to this. And in terms of the global impact, there were, as you know, an isolated case in Dallas, Spain, but these were of workers who had been in the area and really no regional spread. So as far as a pandemic goes, Ebola can be considered more of a regional, West African type of pandemic. But just this week, and this is some good news, the ongoing epidemic in Congo, especially in the south and southwestern regions, has been declared contained, which is great. There is a smaller epidemic still ongoing in the northeast part of the country, and vaccines are being deployed in the area. So hopefully we'll see attenuation as time goes by, and we can develop the immunity in the population. And that brings us, of course, to where we are today. And the impact of, you all know this picture, we see it constantly on the news and in every newspaper, et cetera, the SARS-CoV-2 coronavirus. And you can see the structure of it, and these little red things sticking out are the spike proteins, which are really where all the action is. I'll tell you a little more about that. But this is our current pandemic, and probably the most aggressive and rapidly spreading one that has really moved across the world. The fact that we're having this discussion over a Zoom conference and we're not sitting in the same auditorium to share our experiences gives you an idea of the impact of this disease on our society. And we all know about incredible economic impact. And this is one that we know this story, December 31st, in fact, New Year's Eve, the first cases of a new kind of pneumonia were reported in Wuhan, China, in the Hubei province. And this is a part of the world, East Asia, where respiratory viruses are endemic. A lot of influenza viruses come from this part of the world. And certainly in 2003, I guess the precursor, if you will, of this coronavirus, SARS, the initial SARS, was also coming out of this part of the world. The name SARS-CoV-2, of course, implies it's a SARS type coronavirus, but 2, so it's different and somewhat distinct. But it emerged with, and we know that there's, again, think of these themes that I talked about earlier, a huge effort to suppress information, a political overtone to it, trying to, keep information contained. And in the early days, over 5 million people left the city of Wuhan into the rural regions of China. And the exact nature of contact tracing and caseload is not entirely clear from China, but this is a disease that, globalized spectacularly, really spread around the world. Now, before I show you some of that, go back to this theme of the idea of zoonotic origins of disease. So once again, we see the bats showing up here, and bats being perhaps the primary reservoir, not just of SARS-CoV-2, the COVID-19 virus, but also the original SARS and another disease called MERS, the Middle East Respiratory Syndrome, which came out in between SARS and this, so around 2008 or 9, I believe. And so bats being the principal reservoir, but you'll see here in this picture, this cartoon, that again, an intermediate vertebrate population. And this is just, good trivia for your next cocktail party, but the initial SARS virus went through what are called civet cats. MERS went through camels, which seems appropriate and where it comes from, the Middle East. And SARS-CoV-2 seems to have a role with something called the pangolin, which looks a lot like an anteater. But again, zoonotic reservoir, vertebrate intermediates, and into humans. What the exact link is, some people say it's, the consumption of bats or, the consumption of these other animals. We can't be 100% certain, but what began as this sort of, large vertebrate reservoir has progressed with really, really fast human-to-human transmission. And again, global travel, commerce, and these factors have influenced it. And I'll show you just a couple of the numbers, these are from June 23rd, so just a few days ago, but truly staggering numbers. You see the US is, 120,000 deaths. And certainly some of the other countries that have been very affected, Brazil, Italy, France. India is having quite a surge, over 5,000 new cases a day now, and Delhi is undergoing a huge testing. Almost 29 million people are going to be tested in the city of Delhi, the metropolis. And important things to remember about this disease as we approach 10 million cases worldwide in the matter of months is highly transmissible, highly variable presentation of this disease. And I think as physicians, we all can appreciate what I would call spectacular biology of SARS-CoV-2, the thrombotic complications, the immunologic complications, cytokine storms. It's something that we haven't seen in viral diseases. I haven't seen it as an ID doctor ever. And so really quite amazing. Possible vaccines, there are many that are being deployed now and going into trials around the world, China, Germany, US, and let's all pray. It would be a miracle, I think, for a vaccine to come out so quickly for a disease like this. They've been trying for SARS, the original SARS from 2003, don't have a vaccine yet, so we're not sure. Treatments, there's some good stuff in the news about maybe the role of dexamethasone for people who are ill and ventilated. Remdesivir has been used, but again, nothing so far at the early level as far as an oral pill that one could take. Just as a sidebar, my own research lab, we're involved in drug discovery and molecular design, and we actually have a compound that just got licensed in the last 2 weeks by a company in England, which may have activity against this virus. So we're, again, part of the team of trying to find things that can control this. And, this map, you see it all over the place. These are the global impacts of this disease. And again, something that started from this part of China has now gone globally, and I would say is chilling at this point. Still in the United States, many states, as you know, are having significant rates of increase, rolling back of some of the restrictions. India, Brazil, many countries are now in Latin America facing a stupendous rate of increase. The other
just to let you know, about 4 minutes left.
Okay, yep, just a couple more slides. The case fatality rates, and again, there's so much that's not known about this virus, but why in some countries, Italy had a very high case fatality rate, over 12, 13%. Other countries have had very low rates. There's not evidence that there's just a huge heterogeneity of the viruses, so much more needs to be learned there. The good news, and I really sincerely hope and pray that this curve holds. This is as of June 23rd. Though the cases may be going up in the US, the fatality rates are going down. And it could be that we're seeing, some people call it viral attenuation. It could be that it's affecting younger people more now. We're attuned to it and we're taking more preventions early. I don't know. But this is good news. The rest is still kind of scary. And I want to close by just saying I talked about 3 pandemics, and all of which originated outside the US. I don't want people to leave the talk thinking that the US is some great place where everything comes in and invades us. No, it's, there are many emerging diseases that have originated here. We've had Lyme disease, the E. coli 0157, multiple things. And this can happen anywhere in the world. And to sum up the things I said, when you think about what leads to emergence, environmental factors, human factors, and that could be climate change, human factors, and commerce, travel, microbial factors, so the evolution of new species that can cross hosts or express hypervirulence like drug resistance. And then the important thing, and where I hope we can learn, is that the societal acceptance and the societal response to emergence of disease and pandemics is critically important. There is no role for denial. There is no role, as you know, for politics, trying to determine whether, if you wear a mask, do you support one party or the other? Is sheer stupidity in the wake of these kinds of pandemics. And we've seen this over and over, the role of politics in HIV/AIDS, in Ebola, now in this, and it's time for us to learn from it. So hopefully we may not be able to always control the microbes. We may not be able to control the animal populations as well as we want, but there are things we can do. And if we think about the bigger picture, not just of emergence, but why it occurs, maybe we can better handle what happens in the future. And let's all, again, pray that treatments and the vaccine come up soon. So that's it for the talk. And certainly if you have some questions, I'm happy to answer them. Thank you.
Thank you very much for the great presentation and excellent review of HIV, Ebola, and now COVID. There are several questions that have come up on the chat and the question answer session. One you partially answered on vaccine availability. Do you have anything more to add?
Vaccines? Well, I wish I could tell you more right now. There's, as you know, the Moderna vaccine, which is a US-based company, has shown that it can induce antibody responses. A Chinese vaccine, which is an mRNA-based vaccine, also induces antibody responses. But the two big questions about vaccines: one, is the antibody response durable? Will those antibodies last long enough to go through a season? And that's obviously something that has to be answered. Two, what level of antibody is required to protect against another challenge? And I don't want to sound negative, but coronaviruses in general, the causes of common cold, for example, are notoriously hard to get immunity. That's why we get colds all the time. And, let's hope that the kind of antibody responses that are being induced are protective. It has been shown that many, people who've had COVID and have developed antibodies are not necessarily immune from another round of infection. So a lot more that needs to be studied. And again, I would be cautious about statements that, the vaccine's around the corner, or, wait till the fall. I don't think that's necessarily going to be happening.
Thank you. You already answered one of the other question on the protection by the antibodies.
Right.
Could you also make a comment on the herd immunity?
Certainly. And I'm actually looking at the chats here on the side. And so, herd immunity, and the previous speaker had alluded to it as well. We know so much about it through pediatric vaccinations. And the concept is to be able to get enough collective immunity to be able to have protection for the next wave of infection. And given that even though there's 10 million people, let's say, who've been infected in the world, there's about 7 billion people as a population. So the actual percentage is extremely low. Natural infection is not going to bring this about right now. Even if we assume the CDC's thing of about a 10 to 20 multiplier, the number of people truly infected is much higher than those tested. That's not enough. Vaccines are going to be required. And so really the concept of herd immunity, I think, will be accelerated when that occurs. And I'll just add, since I see several comments here, that about masks, and I'll just make a quick point if I could, that, and this is something I tell our residents and students and everyone, in the absence of a vaccine and a treatment for COVID-19 virus, the only thing that is working is prevention of transmission of the virus from person to person. We don't have vaccines, we don't have treatments. Social distancing works to a point. I mean, obviously if you can, keep 6 feet or 8 feet apart from people, great, but that's gonna be impossible in the bigger picture. At some point, humans have to come close. Masks are critically important. And I just cannot emphasize this enough. The concept that maybe we shouldn't wear masks or there's a constitutional right to not wear them, I think is a misguided concept. They do work. They've been used with, those of you who are surgeons in the audience know, you wear masks because you can prevent transmission of pathogens. People have been wearing masks in East Asia for quite some time around flights and things like that. They work. And wearing them in public, especially when social distancing is not possible, I think is very important. I didn't get into all the data on persistence of the virus and aerosols and how long it lasts in an elevator, because that'll really ruin your weekend because it's quite scary. But when you're out in public, wear a mask. I just can't say that enough. And wash the hands. Every hour to 2 hours, wash or use some kind of, because that we just have to control it until there is better, vaccines.
Thank you very much. I think we have gone 5 minutes over, but it was an excellent discussion and very informative and very useful, not only just for the knowledge sake, but for personal use as well.
Great. Well, thank you. Thank you for the opportunity to speak. I really appreciate it. Thank you.
Thank you. So that brings us to the end of the morning session. I will hand it over back to Dr. Vemuri Murthy for the final comments.
Thank you. Hope you all enjoyed today's presentations. I thank our distinguished speakers, moderator Dr. Rohit Kumar Vasa, and all of you for joining today's presentation. I also thank you for your support of the newly initiated AAPI Chicago Medical Society virtual CME programs. So this ends today's CME session. We look forward to your participation for tomorrow's session 2, the last day of our CME sessions. Thank you again and have a nice day.